Hey guys, happy Friday. How is everybody? It is Friday the 13th. I don't think we have a
Actually, do
jury.
not have our jury back yet. So
No
I
jury.
guess it'll be Monday before we continue with witness testimony. However,
What homework are we going to get done today?
I'm hopeful that we can get through some further evidentiary issues today. And I know we can at least finish going through the last 12 pages or so of the exhibit and witness list. And beyond that, I don't know whether anybody's ready with any of the other issues that we were going to get to at some point or not. So y'all just kind of have to let me know. Oh, sorry, y'all. When they tell me we're ready, and that everybody's here, I guess I should stop and actually look. Okay. Well,
Was that Doug looking out for Matthews not being in the room? And Steele looks prepared as usual with a ton of files. So, if you guys missed yesterday, the jury was dismissed right before, approaching the lunch hour. It was really 11. And then after a 3-hour recess, interesting. Look at Doug all dressed up. They come back and they just did evidentiary issues. And Love tried to fight about those plea deal emails again.
didn't know you weren't here. Came in because they said everybody's ready.
Squeak.
All right, so if y'all can give me an assessment of what we're ready to discuss, and if you think it's going to carry us through the full day or not.
Good morning, Your Honor. Simone Wilson for the state. Given the instructions that we received on Wednesday, we're working through reducing the wiretap. We're working through the research on the case law that's due on Monday.
Okay.
But we are ready to go through the exhibits for the remaining witnesses from 61 all the way to the end. I believe that Dropbox was served approximately 2 weeks ago. I'll pull up the exact date in which it was served. And so we're ready to move forward. I don't know if that will carry us through the entirety of the day, but it is about 40 something witnesses that we could go through.
And on the defense side, anybody have anything in particular that you're thinking today would be a good day to discuss?
Myself and Attorney Steele talked about this last night, and the only thing that we were thinking about was the wiretap, but it sounds like we're gonna wait for the state to try to pare it down before we tackle that. So I think that's all we have.
Okay.
Salvo court is open. I know I challenged the jail call of Mr. And by the way, good morning, Your Honor. Good morning, everyone. Arnold on January 10th, 2015. And there's some, I believe, on the next day that the state may seek to admit. And a lot of it is, in my opinion, irrelevant. I don't know if we're going to listen to those calls for this honorable court to pare down or if the state should get together. But there's a lot of talk about food and girls and things like that. In addition, and I'm not saying, you were interested, and I didn't say anything about Miss Morton being supposedly at the Texaco on the recording, and you said, oh, that may be enough for a conspiracy. I don't believe it is. I'd like to talk about that. But if you admit that, does your honorable court understand OCGA 24-1-106? So if that recording comes in, well, then I'm asking for guidance. So if that recording comes in, and if Miss Morton is not a witness, the state spoke with her, they put it before a grand jury, and they had a court reporter, and they did audio recordings with her at her probation officer's office. And under the rule of completeness, it is, on that recording, it may be something that the state thinks is interesting to the jury, but it would be totally misleading if they're saying Mr. Williams is at that McDonald's. So my point is, another recording, another transcript, sworn testimony for this uncalled witness, I would seek to introduce through cross-examination of Mr. Sprinkle. He was at both of those places, and I believe that I would be able to get it in under 24-1-106. So I say that just because that's another issue if you want to do that.
Okay, so the other recording is an entirely different time?
Date, time, location, Absolutely. And there's two, like I said, one's grand jury sworn testimony and one's probation officer.
Now, what's interesting is we have recordings when it's Michael Sprinkle. Is that what I'm taking away here? But so far, not anybody else.
So my understanding of 106 is that it's if a part of one recording comes in, then in fairness, if the other party seeks to introduce the redacted or unintroduced part of the same recording in order for it to give a complete picture, that can occur. But I don't know that that means an entirely separate recording from an entirely separate date with entirely separate people communicating. So if you have law that indicates that, then I'll consider that.
So it's OCGA 24-1-106, I'm quoting, when a writing or recorded statement or part thereof is introduced by a party, an adverse party may require the introduction at that time of any of any other part or any other writing, recorded statement, which in fairness should be considered contemporaneously.
All right.
So if I'm reading that wrong, I apologize,
If
but
those are the words, then you might have a good argument.
okay. I just want to bring that up since you're
Okay.
asking for issues.
All right. And is the state, I haven't heard the contents of that phone call yet anyway.
You're right. I think that we can discuss with Mr. Steele the parts that he's discussing. I believe that we can come to an agreement on what is not, the parts that are not relevant in that phone call. And if we can't come to an agreement, we can bring it to the court. But I think it's something that we can.
Okay, well, I don't know that his objection is simply relevance. I think he has a relevance objection to parts of it, but he's saying other parts of it, if there is something potentially misleading and there are other recordings that establish, that, it actually mean what it sounds like it means, then he would seek to introduce those other things that would clarify that.
Yeah, so my understanding, if it's the call that I am thinking of, and if it's the call that was discussed yesterday, and I would need to listen to it again, I believe there's an inference as to Mr. Kendrick. I believe that in that call, and if it's the same call, and I'll need to just confirm that Mr. Bradford or Mr. Arnold calls Mr. Bradford while he's in custody. And at a portion, Mr. Bradford is with Bushi. Mr. Arnold asked Mr. Bradford, where is Yak? And Mr. Arnold responds, we're waiting for him. Mr. Bradford or Bushi, Ms. Morton, says we're waiting for him. And they were talking about Yak Gotti. So I don't know. I will need to listen again and see if there's any other reference to Mr. Williams, and I will listen again to make sure. But my understanding is, and if this is the call that that was discussed yesterday,
Yeah.
then I need to listen again to see if there's a reference to Mr. Williams and being at the McDonald's, because my understanding is of the call is a little different, which is the only
Okay, well,
reference is Mr.
Then y'all just
Kendrick.
take another listen to it and get together on that. All right, and y'all can present what if you resolve, great. If not, we'll present whatever the issue is after y'all both had an opportunity to listen to that. And if necessary, whatever part of the grand jury recording might then be relevant.
And excuse me, Your Honor, and I apologize, since I wasn't here yesterday. Are we still litigating whether that call comes in?
Yes, we haven't made any kind of determination about that.
Okay,
In fact, Mr. Howell, I think, asked that we hold off until you were present. So we just sort of, mapped out broadly what the issues might be, but we haven't listened to the call or made any kind of
Okay.
determinations about it.
thank you, Your
And it
Honor.
sounds like we'll hold off on that for a little while anyway, and it may or may not end up being necessary to litigate anything about it.
Thank you.
Okay. All right, so do we think I guess the Dropbox with the evidence is on witnesses 31 through 60 is that going to track sort of this witness chart that we were going through yesterday?
It should be, Your Honor. I thought, if my memory served me correctly, that we finished up to 60. We had completed
I thought
60.
we had two.
We did. We completed 60 and we were at the
Yeah.
final group. Yes,
Yes.
Your Honor.
Okay, so, all right, so we were kind of using this chart yesterday. So to determine, okay, are there things that we need to litigate? So if we're
Yes,
gonna
Your
just
Honor.
Weeks are gonna be out of
continue along with
control.
that, and then if there are things we need to litigate, then we'll jump to that Dropbox link and pull up that evidence. Is that the suggestion?
Yes, Your Honor. And I'm searching to see the date that we sent the Dropbox link so everyone can find it. No. Yeah, I think it might be August 27th, but I just wanna- Yes, it's going to be on August 20. Oh yeah, it should be August 26th, and we sent it around 11:42 p.m. And if it's not, let me make
No jury today, you guys. And we're going to give a big, big thank you to Mr.
Okay,
Satchel here,
I don't
gifting
think that's the
5 to
right
start off the
one. You're right.
memberships.
Evidentiary videos is what the reline is? Is that what you said? Oh, yeah, she was saying she didn't think it was the right one either.
Yeah, notice how we can't hear them talking at the states table right now. And the media's being cautious and muting the sound anyway. And guys, what do you think? Do you think no love today? Do you mind no love today? Then we also have a big, big thank you here, Taybiz TV, who had a hilarious stream about the Unk, the Shay Shannon Sharp last night. Let me get the link. Gifting 10. So show some love to Taybiz. It was a hilarious stream. I didn't actually know about the Shannon Sharp situation, and when I found out what it was, I was like, oh boy. But it was great, great coverage. And Andrew Henson, this is a big, big thing that we're talking about. You add another layer to it here. I haven't seen anyone else catch this, but if Merchant is called, that could mean Steele is crossing his own personal attorney in the contempt matter. Oh, that would just be beautiful. Beautiful, beautiful, beautiful. And I think, I think attorneys in general try to have respect for each other, but I really think both Ashley Merchant and Brian Steele have a two-way respect for each other. Maybe Adams would handle the cross, but, my same read of the endearment, I say would apply. So that would be extremely, extremely interesting. And again, you know, these witnesses on cross don't typically seem to be hostile in general towards the defense. Maybe they just don't want to be there, but they usually seem hostile towards the party calling them. So it's not like I expect
can't
Ashley to
find the
be
email, but I'm
harsh
just
to
gonna
defense.
resend the link right now.
And again, her client, you guys, Martinez Arnold, took a plea deal. He, you know, I think it was 12 years total, 2 served, 10 on probation. Unlike the others, he does not have to stipulate that or acknowledge that YSL is a gang. And he also retained his right to invoke the fifth if he takes a stand. So he's going to be a very interesting witness. And I imagine if he takes a stand, even if Ashley doesn't, Ashley might be in that courtroom. Maybe we'll hear her lodge some objections or concerns to help protect her client. So Martinez Arnold will be a very interesting witness to watch out of these witnesses that have plea deals. And also known as Duke. His AKA is Duke.
Yeah, if you don't mind.
Okay. I just sent it, so it should be coming soon. Yes, yes.
So super thank you for the 5, Andrew. And Steven Satchel updated his thoughts on the plea agreement. I can find that. I can get a link for it. Leah's dad says, morning K&W gang. Whitaker is cool with the state's theory as fact, but seems exhausted by the amount of case law the defense has on hand constantly. Well, sometimes she's like interested in hearing the case law, and then she's like, that was great, but no. like, all right, lady. Listen, lady. Good to see you, Leah's dad.
Ms. Hilton, it looks like it needs a password, and that wasn't in what you sent me just now.
Okay, hold on.
And then Brina says, love's exhausted from all her reaching. All the time she's talking.
Chrisfield just forwarded what you sent, so I think we'll all need that as well.
All right, hold on, my Dropbox link savviness isn't.
Tired from reaching, chasing her tail, running her mouth, and dancing around the issues. She needs to rest. Hopefully it's retirement. Oh, boy.
Okay, I'm going to resend it. I found the email. The email was sent on the 30th. I believe the link will be in this email that I'm about to forward to everyone.
And the password.
And the password.
Okay. All right, everybody's about to get a different email that'll have the password also.
I wonder if the state uses secure passwords. Or if it's just like love 123. Rico 123. Oh, you need a capital letter, capital R, capital I, capital C, capital O, 123.
I just forwarded you.
Password slime, Rico Slat 372. They did it 2015. Wait, is 372 the numbers that Woody uses in his username? ABC XYZ. They did it 000. Glanville 321. Password 1. Yeah, a lot of password 1s going on here. Oh, we updated the P. Hilarious. Dropbox 1, Rico Slat. Rico 123 pound. Or hashtag. Love is the best
Okay, this
prosecutor
starts
ever.
with, Adrian Ansart.
Yes, Your Honor.
Okay. Is everybody in there now?
Mistrial 403. I hate Steel 1. No. YSL Rico with a 1 for the eye. That's good. Slat. We the Best 2015. I Hate Love 1. Hunter 2. That's a reference. Salad Nuts hashtag. Password Take Thug Down. Woody Did It 30 Gang. Planters 2015. Wipe Thug's Nose. Man Juice. Steel SMD. All cap, no facts, 1, 2, 3. Planters with the $ for the S
Does
is
everybody
great.
have the Dropbox link up?
Woody number 1. Spaceballs luggage. Willis and Wade forever. Lil Love, Love Lies. .24365. Strike that from the record. Dropbox 1. I Need Some Love. I'm a Liar 1, 2, 3. At this point in time, 404. How come nobody's put Lil Mike and Quez in a password? Play this 1, 2, 3. Oh wait, we got Rico with a K. No one will guess that with the K. What about Believeland 1, 2, 3? Buffering 403. Rebuke this. We've gotten through a lot of passwords. They haven't gotten much done today. There we go. Quez and Mike is real 100%.
All right, so number 52 is Miss Ansart. She's going to be the records custodian for the Instagram records for a couple of the co-defendants. Any issues we need to litigate with her?
And Your Honor, I'll say 52 and 53, we already litigated, and the reason why it's in this folder is to be consistent with this document. So we looked at Sergeant Matthew John Pierre's folder
Okay, great.
as well as Ansart's
All
folder.
right. So moving on to 54. Anything?
Password quay.quay.quay. Yeah, this is a struggle day so far. Shout out to Phil who says, they need to keep Miss Love out of court on the days the jury is present. It would be strategic at this point. She comes off as arrogant and shady in my opinion. Yeah, and I think without her, I don't think we would have had Derek Wright on the stand. I think that would have been a big win for the state to just let Munk Tunk ride off into the sunset and be done when he was done. Because I think I think the chat felt like there was a greater chance of Antonio Sledge's credibility issues being higher before Derek Wright took the stand. And then when Derek Wright took the stand, it kind of solidified, well, actually, Antonio Sledge was characterizing the plea negotiation pretty accurately. So his credibility went higher. Just stupid. Just stupid. Yeah, I think I Hate Steel 123 is hilarious. Oh my goodness. And yeah, good reminder, no jury today. The jury, it seems like, one of the jurors is having an issue, maybe Hell. They sent the jury home almost midday yesterday and kind of dealt with some evidentiary issues yesterday. A lot of it was pushed back.
No, because 52 and 53 are already folders that we've already gone through last week. So Sergeant Matthew John Pierre, these are the same videos we talked about, I think, earlier this week as well, where we went through the timestamps of the video. So we already talked through this folder. It's a duplicate folder. So we really should be on 54.
All right, so if everybody will open folder 54 for Officer Rogers and tell me whether
All right, we
there are
finally
any
got something.
issues in the evidence contained within that folder.
It's been 14 minutes since Doug spoke. That's how much time we just went through, 14 minutes. Red Bunny says, many won't let you mention another content creator's name in their chat. That is why your channel is doing so well, because you promote and support everybody. Yeah, I'm all for it. I mean, before I was on screen, I lurk everywhere in everybody else's chats. Not even lurking, I do participate sometimes. But the way people listen to background music for work is the way I listen to people streaming on YouTube. So I need those people to have the motivation to keep creating content so I can keep consuming it. It's a bit altruistic. It's a bit benevolent. But always, and you guys know the drill, especially when we're leaving for the day and need somewhere else to go.
Yes.
May I ask the purpose of the medical records? I think there are pages 1 through 108, I believe. Or maybe 5 through 108.
Yeah, we might not get into the medical records. We probably won't get into the medical records, but because they are Officer Rogers records, we included them in the folder. We believe his testimony will be sufficient. We don't intend on calling a doctor. However, we just included it within the folder because it related to Officer Rogers.
Okay, so those, you probably wouldn't tender those anyway, and if you did, they most likely would not go out to the jury.
Yes, Your
and
Honor.
probably wouldn't be displayed. Okay, is that sufficient?
Okay, and looks like there's probably about 3 hours of body cam. My understanding of the body cam is at least a portion of it contains the actual altercation between Officer Rogers and Mr. Eppinger, which I understand, but is there any other purpose of the body cam that they would be seeking to introduce in this case, or the state would be introducing in this case?
So the portion of the various body cams that the state intends to introduce, one, yes, the interaction between Officer Rogers and Mr. Eppinger, then portion of the interaction between Sergeant Johnson and Mr. Eppinger, and then a portion of the apprehension of Mr. Eppinger. But that probably in total is less than an hour. I would think if it totals 30 minutes, but it's probably only about an hour total of all the different body cams in this case.
At some point, can can we just get the times that you're seeking to introduce?
Do you have those now?
At
I
some
don't have
point.
them now, but it's quickly for me to get them. Not by the end of the day, I can definitely get it to them by early next week. The various timestamps and the various body cam videos.
Okay. All right, so you'll get them the timestamps so that they'll know if they feel like that's the reasonable and relevant portions or something more than that. All right. And then I guess the same with whatever the other medical record is.
Yes, Your Honor.
All right.
And if we're moving on to the next folder, Sergeant Erin Brown, she is only bringing in Officer Rogers' body cam as a custodian of records, given
Okay.
the trauma of the incident. Officer Rogers, we're not going to bring the video in through Officer Rogers, but through Sergeant Brown. So that's what her folder would entail,
Okay.
which would be the body cam video.
All right. So on to Sergeant Johnson then. What all is this?
So that is the overall surveillance video of the entirety of the interaction with Mr. Eppinger and both Officer Rogers and Sergeant Johnson that's not captured on body cam video.
All right. And so we'd only be watching whatever parts we wouldn't have otherwise seen.
Yes, Your Honor, and we'll get those timestamps as well.
And while I don't love that they don't just trim their video, I think Hilton gets her job done with the start and end points, at least knowing the timestamps. Like, if this was Love doing this, she'd be like, my team.
All right. McKessie, is that how you say that person's name? McKessie.
And he falls into the same category with the body cam. He's that last portion that I referenced, and so we'll get the relevant timestamps.
I'm confused. What's he doing that?
So he was a part of the apprehension team. So once Officer Rogers was shot, he was taken to the hospital by other officers.
Yeah.
And so later when they went to get Mr. Eppinger, McKessie's involved in that portion of the video.
So under the Rogers folder, the part that you said was the apprehension of Eppinger, that's not actually, whose body cam is that, or what is that? Or is it the same thing, just under two separate witnesses? I mean, you had mentioned with the Rogers file, the interaction with Eppinger, Johnson's interaction with Eppinger, and then the apprehension of Eppinger. So is that actually going to be coming in through McKessie, the apprehension part?
The apprehension part is coming through McKessie, but what we've done is all of the body cams are in one evidence.com folder. And so we.
All right, so, but that's the same thing in two different
Different
places.
folders.
Okay.
Yes, Your Honor.
All right, so you'll get us those timestamps. All right, then we move to Captain Wofford. And what's this about?
And I'm dropping the link right
So
now.
Captain
Around 6
Wofford,
p.m., I'll be on Nick Starrow's YSL Friday panel.
That
I
is
know
the
he always invites a bunch of
surveillance
guests,
video
too.
for the stabbing of Mr. Rayshawn Bennett. And it shows the entirety of that interaction between Mr. Myrick and Mr. Bennett.
When you say surveillance, I'm seeing, correct me if I'm wrong, Captain Walford is the gentleman Captain Wofford is a gentleman who came into the pod after the altercation and was wearing the body cam?
Yes, but he's also able to serve as the custodian of the Pelco system, which is the jail surveillance system.
Okay, but in this folder, the Axon stuff, that's Captain Wofford's.
Yes.
Okay, and so we'll make sure that you will make sure that this is not cumulative.
Yes, Your Honor, because the body cam videos only once the stabbing occurred. The
Okay.
surveillance shows everything leading up to the stabbing.
Okay.
And Your Honor,
Mm-hmm.
my other concern now, I'm going off of my prior review of this.
Mm-hmm.
My recollection and belief is that Mr. Bennett on these body cams doesn't say a whole lot, but at this point, my understanding certainly is Mr. Bennett is not testifying in this case. So I just think we have to, and I'm going to ask the state to make sure that anything that they seek to introduce to these body cams does not contain testimonial statements concerning the events that had occurred.
Yes, I think what's on the video, we would argue would be excited utterances because it's a lot of once he was stabbed. I don't believe he made any statements to the police regarding who did it. And so our intentions would not be to introduce anything like that. It'll be primarily once he's apprehended, more of the excited utterances and present sense impression of Mr. Bennett at that time.
All right, well, so I guess you need to make sure of that.
Right, I don't,
And it may be that you think it's one thing and they think it's another, so we might need a little more specificity about what's coming in.
I don't
could discuss it.
recall him saying too much, but he was definitely being spoken to and asked questions by law enforcement about what happened. So anything he said from our stance would be testimonial. But I don't recall at this time him making any statements. But
Your Honor, we can look at it and talk about it and see if we can come to an agreement. And if not, we can bring it to the court's attention. But I think it's something that we could resolve short of having to have the court intervention.
Okay. I mean, these things like the disciplinary hearing dispositions and things, those are just in there because maybe somebody might need to refresh their recollection about them or something. I mean,
Yes, Your Honor, these aren't things we intend to introduce, especially if Mr. Bennett is not going to testify. If he ends up, then that'll be a different story for a different day. But
And Rayshawn Bennett is why I
all
found
right,
it to
well,
you guys.
the defense, y'all have had this evidence in this format under these witness folders for a while now. So it's also incumbent upon y'all to take a look at it and be prepared to say, well, there's, absolutely no way evidentially that XYZ should come in if that's what you think. But yeah, it would be helpful for us to not have to litigate stuff that the state doesn't really intend to put in to.
Your Honor, I would.
Yeah.
So there's a surveillance video, as you know, and then a body camera, the law enforcement comes in thereafter. Anything outside of that at this point, I would be objecting to. It's my strong memory that Mr. Bennett did not make any statements to law enforcement. If he did, it's confrontation clause if he doesn't testify. So anything other than those two items, I would be objecting, if that helps.
All right, so Ms. Hilton, take a look, and if you think there are some statements that are shown on any of that body cam of Mr. Bennett that you believe come in as a cited utterance or present sense impression, then, and you intend to introduce them, then you can maybe call that to our attention and we can make a decision on that. Okay.
And big
All
thank you
right,
to Army Nurse saying
someone-
good morning to everybody.
Wait.
Ready for the mendacity
Have we
today?
already-
It might be better than usual with no love. And then big shout out to Love K for being a member for a whole month. That's 30 days with us. Appreciate that. Tamika says, attorney writes at the precedent that, yes, all/most of these pleas were just signed under duress. I love the way that, the defense attorneys, of course, want to give that impression, make that argument in front of the jury. Then they call up an attorney that's not associated with any of these co-defendants to also make that same argument. Like, beautiful for the defense, stupid for the state. Especially since I think Attorney Wright took it one step further to say it's really a choose your battle situation where we give up some things that might not be true. That's really problematic for a jury to hear. Thank you so much for all your support and for being an awesome mod, Tamika.
So if the defense, y'all kind of seem to be, I don't know if y'all are, I don't want us to be doing a real-time evaluation of this amount of evidence. If we're ready to litigate these things, great. But if we're not, y'all just let me know that.
I've reviewed the wiretap from Mr. Sumlin, but I have not reviewed specifically what the state has pulled out, so I need to do that.
Okay. Is that kind of true for everybody?
Is she trying to close up shop?
Question.
Yes.
In this folder that appears to be a bunch of audio files, the first folder under Sumlin, am I correct in my belief that that is all the calls from the wiretap that you all seek to introduce at this time?
No, so these are the calls from the wiretap, primarily looking at the ones that we identified for the co-conspirator statement. So some of these will probably be reduced by the co-conspirator statements once we reduce those as well. But this is just a duplicate of that folder.
Understood. So it may shrink.
Yes, yes. And we would have identified all the Sumlin calls once we finish with the co-conspirator analysis.
When are y'all gonna finish that?
That's what we're working on, that the court asks us to have a reduced list by next week.
Okay.
Kind of sounds like the answer is no, Whitaker.
So do y'all maybe want to take today to work together and or separately on a whole lot more of this stuff? Okay.
Yes, I think that would be beneficial, Your Honor, and
All right.
productive.
So we
All right,
will.
so I don't want y'all to leave and go home and do something else. I want y'all to stay here and work, okay?
Yes.
All right,
Stay in the
so,
courtroom, or can we stay in our office and work?
I mean, whatever is easier. If it's easier to sit here together and say, things like you've been saying. So, hey, I'm looking at this. Is this what it is? And is this going to be the entirety of it? Or are you going to narrow it down? Or what are the timestamps? I mean, it might be a good idea to just sort of, and the defendants can go back, but the attorneys sort of, review evidence together. Yes.
maybe my colleagues are gonna throw some tomatoes at me, but if the defense attorneys could maybe take a certain amount of time in our little side office and go through, and then maybe either all of us or some representatives could meet with the state at some point today and discuss where we're at. But as I understand it, the information that we would be reviewing on our own would be the contents of this Dropbox minus the wiretap stuff.
Yes, that's fair. Yes.
And we're not going to watch as a group that all the Axon folders. We're going to wait for you all to give us direction on the timestamps on the body cam stuff.
Yes.
All right, and I don't mean just this folder. I mean folders, you know, whatever this is, 52 through 103.
I meant the Dropbox.
Yes.
The entire Dropbox.
Okay, yeah. And to the extent, I mean, we didn't have the Dropbox for 31 through 60 up yesterday when we were walking through those witnesses. We were doing something more general than that. But when y'all get through all of this through 103, if you want to jump back and just make sure we covered everything on those others, you know, do that as well. But then I think maybe the next time we get together, it'll be more productive. Okay, so I'm gonna adjourn us from our trial for the day, and the defendants can be returned unless y'all feel like you need them. But it doesn't, this seems more like attorney work to me. Y'all tell me if I'm wrong.
After consulting with my colleagues,
The
I
fake
think
run.
we are okay. We are fine with if just the attorneys remain and the
Okay.
clients are allowed to return
Okay,
back.
all right, so let's do that. And then today is Friday, so we will reconvene, let's say, Monday at 8:45. All right, and
8:45
y'all
on
spend the
Monday.
day being productive and with your unexpected extra time. All right, you're welcome.
Whew.
And so will we be able to leave?
So we could do a rewatch. I would start a separate stream just to keep it distinct. I've got some pre-trial clips. I've got, I think DK Walter Murphy would be a great one to watch. Another, you know, plea deal situation, didn't really want to be there to testify. He was on the stand for several days, so it might be a situation where we get a piece of how he's dealing with love on direct, and then we can skip to cross. But we could do a stream if you wanted to, or you could be like, Kat, we're tired of you, go away. Either way, around 6 p.m. Eastern is the YSL Friday night panel. The live event isn't scheduled, so just sub to Nick Starro, and you'll be able to see when he actually starts that at 6. Oh, we could do the state Senate hearing if you want, the Georgia State Senate hearing. Okay. Let me get that ready and we'll go through. We could keep that in this stream because it's kind of same topic. Let's see. I think this is it here. Share this tab. And this looks like it'll be it, so if it starts, it starts. So we'll do this. We'll do this. Great, great Audible chat for calling this. I forgot about this hearing starting like literally in 10 minutes. So that'll be good. And this is about the records request, right? Is this Fani Willis and, the request for public records disclosure and her argument that because of her position, she's not obligated to respond to those requests? I think that's the subject, right? So, cool beans. Let me, I'll change the banner in a little. I'll change the thumbnail and title in a minute. Thank you so much to everyone that is gifting memberships and sending supers in. Big thank you to Felicia. Now, here's the story. You guys are already showing Felicia love in the chat. She gifted 10, so which is super awesome. But she also said, and thank you for the 10 here, Kat, I was gifted a membership like a week ago, and when I found out, I was way too late to say thank you. So as my deepest, most sincere effort of thanks, I shall return the favor tenfold. Love you, by the way. So this is super sweet. And it is true, when you're in the chat and you get gifted, you can kind of see who gave you the gift. But if you're not paying attention to the stream, or the stream's moving too fast, or you just see an email, it doesn't tell you who gifted the membership. So Felicia's like, well, I don't know, and just came in and gave 10 more, which is super generous, very sweet, and I love to see it. It's my favorite feature on YouTube, and love you too. So thank you so much. You guys showed Felicia so much love for that. And then Felicia had also said for the 5, thank you for the appreciation, Tamika, staff, and Factual Lie. So, you guys know the deal. Always mod love in the chat. You can shout the mods out anytime in the chat, but sometimes we like to call extra attention to it with some mod love. And I see people saying, I want a gift. Make sure you click the little money symbol where you type and turn the setting on to allow gifted memberships. You won't be able to get one unless you have that setting turned on. Once you turn it on one channel, you're good anywhere on YouTube. So Felicia, seriously, super gracious of you. Thank you so much. So generous. La Mustache Wipe Gang. Aw, cute picture. Says, good morning, gang. Friday the 13th. No jury. No G-Love. All day. That makes you think of the music group G-Love and Special Sauce. Miss Love and Nut Juice. Good to see you. Nope, we're going to call an audible and watch the Georgia State Senate Special Committee. It's going to be a good time. Opposite of Amnesia says, Hilton better be careful. If she gets too much done and makes love look bad, she'll be next for Rico. Maybe my own PTSD from work. I kind of understand. I think that's a real phenomenon, right? And it's a positive feedback loop in a bad way. You do too much and then suddenly you get all the expectations on you. So, sometimes you need to find a balance. So very interesting, very interesting. And I really do think Hilton will be more productive with this time than Love would be. But we'll see, guys. Monday, can you imagine if the state is late on anything that was due Monday? And they've had yesterday and today for extra time to do their homework. Because Love was asking for longer than Monday. So we will see. Thank you so much for the 5. China Eyes is sniping people out here. China Eyes said, look, I'm going to make someone a member. And then that person 2. And then that person 3. So shout out to China Eyes. And look at us, both rocking our caps. Love to see it. Thank you so much. Sonia says, literally making up the case as they go along. For 2 years. For 2 years. At least for the case itself, not the investigation. It seems like they were doing it since the investigation, too. Michelle Warden says, absolutely great chat. Love the chat. Please hit that like button. Thank you for the 2, Michelle. Always good to see you. I like to hang out with you in other chats. It's good to see you here. Mason Martin became a member. Shout out to Mason Martin. Welcome to the gang. Ike said, and I'm glad that this wasn't actually a glitch where it came through 3 times. It seems like it's only 1. Morning, Cat and chat. Shout out to the mods. Heck yeah. Casper's going to be Professor Xavier. Jason Hodges is Wolverine. Love that. Factual Lie is Cyclops. Steph JK is Jean Grey. Drea is Jubilee. And the others we still need to do some nicknames for. That is awesome. So now we have a chat gang with X-Men mods holding it down for us. Thank you so much for your continued support every day and great commentary, Ike. That's what Leigh said. It says, on April 11th, 1991, Shannon's mama called Thugger's auntie. That's furtherance of the conspiracy because Thug was keeping Shannon apprised of his birthday party plans at Discovery Zone. So YSL the label. So guys, shout out to Discovery Zone. I think that might have just been an American thing, but do you guys remember Discovery Zone? I used to love, that's where I wanted to have birthday parties. I used to love going there. I don't even remember if I like hung out with the other kids. I would just be running down. There was like this rolly slide you can go down and it would like slide you into a ball pit. Oh my God, I loved it there. I loved it there. Post-COVID days, they would never launch something like Discovery Zone ever again. Oh, but I loved it. It was such a good time. So this is hilarious. This is really, every time I hear them in court say, oh, they're keeping each other apprised. I'm like, not really. That's really, maybe once in a while, sometimes it might seem like that. That could be a reasonable conclusion. But other times it's like, no, that's not what they're doing. They're just saying like, look, I'm caught up. I'm in jail. How's everybody doing out there? Oh, they're apprising each other and calling shots. No. So this is hilarious and a wonderful, wonderful memory. Leah's dad says, so Love didn't bother showing up because she already told the judge to send everyone home for the day since nothing was done. Cool, cool, cool. She said, yeah, let's just phone it in. Let's just phone it in. Oh boy. I think it was nice to have a break from Love. Just personally. Casey Dog says, I feel like Shart would be a great judge. I think so too, and I think he has a cool temper. So if that's something that he'd be interested in pursuing, I think he'd have a good shot. And I can imagine like his facial expression like smirking when someone's making a stupid or slick argument to him as a judge. That'd be hilarious to watch. So I agree, that'd be interesting. Guys, in 10 years, we have to reconvene for a cat chat and see what has come of the attorneys in this case. New cases that they're doing, have they gone into the judge wing? That'd be really, really cool. It'll be like our own nursing home hangout. Thank you, Casey Dog. Tamara gifted 20 memberships. Holy moly. Tamara. And it's Tamara O. We'll get it right. Everybody shout out to Tamara. You guys are probably already showing love. Yeah, I see a bunch of gifts, green hearts. Tamara's in the chat, scrolling back. Thank you so much for always showing appreciation in the chat for when people gift the memberships and send the supers in. And Tamara says, let's make it a Slimy Friday. We are with it. A Slimy Friday the 13th. There we go. Let's get you in the banner there. And then Lovin said, all right, I'm in. I'm joining the gang. Good to see you, Lovin. You look good in green. Steph JK, thank you, Steph. And by the way, Steph, I'm adding mods whether you use CashApp or Venmo. This is for the mods. If you want to give me your CashApp, Venmo, or I think PayPal works too, I'm adding it to the description of all my videos. So any mods that want to take part in that, make sure you send me your preferred information so I can add it to all the video descriptions. That way anyone that wants to show the mods some loves can do so. So thank you so much, Steph. You look great. I love your new picture. Casey Dog just sniped somebody. Thank you for gifting a membership, Casey Dog. Opposite of Amnesia says, how long can they stall versus dismissing juror? I don't know, and that's a good question. So I don't really see, let's see if Kathy Roussan, I'm hopping over to X real quick. I don't think there's really new information about No, I don't really see an indication of a why, like if it's someone that's just not feeling well. But I imagine at some point it might become an issue, and if one party moves to speed this up because of a juror issue, that's when the court would discuss it. So I don't know. But this trial's gone on long enough, and what's 2 more days? What's another week? What's another 2 weeks? So that sucks for everyone in custody and everyone that's, the counsel that can't attend to other cases while this goes on. But I think the judge is just kind of like, whatever, I gave up on my 30-week goal to get this trial on track. Thank you for the 2 opposite of Amnesia. And then Biz TV says, is this the hearing concerning Glanville's incarceration attempt on Steele? Sorry, working some in and out. No. That would be in the appeals court, and I think that date is October. I can pull up the docket for that. It was October something. So for the Steele appeal, which is one of my favorite things to say, argument date is October 22nd, 2024. And just double checking since we're here anyway. Oh. Did they get another brief filed yesterday? Because we looked at a brief from August. Well, I didn't. A lot of other channels did. We shared the link. But I think there's a new one. So I'm not actually sure how to request documents from this. Let me message some people because I don't know where you can actually download these from. But thank you for asking, Tabiz, because this could be interesting. Someone motioned to file an out-of-time amicus brief, and it looks like it was accepted. So that's a new one just yesterday at 4 p.m. I haven't seen anyone talk about that yet. So Tabiz, you just landed us on a new discovery. Look at that. So while we get this hearing started, that way I'm not just like messaging people like while you guys are here live in the chat. As soon as this gets started in the shadows back here, I'll go and see if anyone can help me access the new amicus filing. That'd be cool to see. But yeah, October 22nd is going to be oral arguments for that, which I'm excited to see, guys. I love Supreme Court appeals arguments. I don't know what it is, but I think the courtrooms that they house appellate judges in, the room that you go to for appeals, there's just something about the echoes, the ambience of the room, maybe the microphones that they set up, maybe they put better care into the sound systems that they put in. It just always is easy to listen to oral arguments in higher courts. Like, it's just pleasing to my ears. I don't know. So we'll definitely do that. Thank you again, Taviz, for the 10 and for pulling that up. We'll go look for that brief. That'd be cool to see. A Willie35 became a member. Thank you so much. As Satchel says, Kat, can your email... Oh, yeah. So I'll send you an email. We'll do that. And there's no body in it, so just sent one real quick to you. Thank you for the 5. I would have seen it in the chat eventually. Thank you for the 1, just pure love of the game, Kavada. Thank you so much. Upstate House to Home, gifting 5. You guys show some love in the chat. Add you to the banner. I always appreciate the memberships because it gives you guys access to those channel emojis. There is no way for a creator to give free access. It'd be a cool feature for me to turn on if everybody could have access to the member emojis, but it's just not an option on YouTube. So, you know, we keep the membership pricing at the low price on this channel, make it easy for you guys to become members. And I appreciate so much that people like Upstate House to Home come in and gift memberships. Super fun for the chat, and it helps, you know, make up the time it takes to do these streams. So we'll get you in the banner there. Always good to see you in Upstate New York. Shout out to Upstate New York. Got a lot of love for Upstate New York. La Mustache Wipe Gang says, Fani set for 9/16. This is about the other lady. Amanda Tipson? All right, hold on. What's the one that we're watching today? Thank you for the update on that. So Would that be filed as an amicus brief? I feel like the states this was the states, because look at the time, unless this is really late, this was 4:11 p.m. yesterday. Okay, so Fani, Cook, and Morelli. Let's dig into this, because it is possible that even though, you know, we looked at the state's letter earlier than this, you know, this is just a late date and time. Take a screenshot there. Let me go right to inside the law. I feel like Phil Holloway will know. And then Christina Weaver fan account is on the hunt for the Supreme filing. So if you're listening, I assume you're listening. Thank you so much. Okay, so it is Fani today. And Ian, let me see what you're saying, Ian. I'm also going to check Phil Holloway, because Phil Holloway seems to really follow these types of happenings. And yes, court is over for the day. I'm going to change my thumbnail when the Senate hearing starts. But we're going to end up watching this Georgia Senate hearing instead. Well, not really instead, since we technically watched all of today's hearing. But we will be watching this when it starts. Yeah, so Dublin Mug, there's been a few, and I think Nick Starr went and read the August amicus brief after reading the state's letter. But there's been something additionally filed yesterday afternoon, which I wanted to double check and see if that's actually really new. It seems like a second amicus brief. Because if you look here, they had to get permission to file an out of time. And at the time that Nick did that stream, if this time is correct, and I think the date, I think the brief that he read was dated for August. I don't think he read something that was dated as 9/12. So I think there's a really good chance that something new has been filed. And I'm wondering, you know, who the friends of the court are, who the amici are. So if you're late joining, guys, court is adjourned for the day. The judge wants the jury to get some work done while the jury's out anyway. And we are instead going to wait and see what happens with the Senate Special Committee, where Fani Willis is subpoenaed to appear. And heck yeah, we can do a thank-a-mod time. The boss says, I love that, hi, Cat and Chat. Thank you for your daily and consistent streams, positive attitude, information, and fun while working. Heck yeah, anytime. Look, I've been in that position where streams have gotten me through my work. Blessings to you and the beautiful space you've created for this hilarious Rico gang. Yeah, shout out to the Rico gang in the chat. That's a really sweet chat. Thank you for the $9.99. Chloe, no, it's not a break. It's over for the day. Sorry, I didn't see this when you sent it. But yeah, adjourned for the day. The attorney's supposed to be getting to work. The state's supposed to be getting to work. But it was really a bunch of silence all day anyway in the court. And the judge was just like, so are we done? Should we be done? Should we be done? Hello, people. Should we just break for the day? And then finally everyone's like, okay. And judge said, good, get stuff done. So that's a summary of the day. And then Kavada says, you said my name right. Yay. I try. I feel like I butcher names a lot, but I do try to
Have
get them
a
right.
quorum this morning. I will
Ooh.
call to order Senate Special
Here we go, you
Investigative
guys.
Committee. We have a full agenda this morning. We have, first, we need to approve our minutes from the last minute, and then we have subpoenaed Fani Willis to testify. According to press reports, she is defying her subpoena and not
Oops.
appearing, but we will welcome her if she appears at some point during the meeting. We also will have a presentation by Mr. Stuart Morelli of Legislative Counsel's office. If you look in your folder, you will note that there is a memo that Legislative Counsel prepared back in 2016 dealing with legislative investigation, administering oaths to witnesses and issuing subpoenas. So we are guided by their work and their legal advice. So I wanted Mr. Morelli to kind of educate the committee and the public on this process of an investigative committee, as well as our subpoena powers. Following that, Mr. David Cook, our former Secretary of the Senate, who's been very involved guiding this committee through the process, will give us some insights from his expertise in legislative procedures and the authority for legislative investigations, the rules that govern legislative processes, and these gentlemen will both be available for questions if we may have them as they try to inform us of our legal standing. So I'll wait just a minute, let everybody take a look at the minutes. We actually have two different meetings that we needed to approve the minutes. We lost our quorum last time. I'd want to start with the May 23rd meeting. If anybody just has any questions about that, just take a look and it'll remind you what we've been doing. I was surprised to see in the press that this is our 6th meeting of the committee. It seems like they're moving pretty quickly as we've been in action since back during the legislative session. I expect we will have 2 or 3 more meetings this fall, and we are continuing to get information from members of the public that have concerns and questions and proposed testimony. So we'll have plenty to do as we complete our mission of investigating some of the alleged misconduct and also ways to improve our statutory authority and laws that govern some of the areas that we've heard testimony on. Everything from special grand juries to special prosecutors to funding aspects of district attorney's offices and accountability for the expenditure of public funds. Those type of things we'll all look at before we come up with final recommendations of the committee. Having reviewed these minutes, is there a motion to approve the minutes from the May 23rd meeting?
Mr. Chairman,
Yes.
I wanted to just make a comment.
Hang on one second.
I was not
Mr. Leader.
present. Okay. I was not present physically at the meetings, but I did participate online. There was not a Zoom function, but I listened to it. And so since questions weren't asked, I feel like I wanted to make that be put on the record. But with that being said, I would make a motion to approve the minutes as presented.
Was there one particular thing about the May 23rd meeting you had a question with?
No, sir, no.
Questions not
No.
being asked?
No.
Okay.
This time, but you did a good job, as always.
Well, I appreciate you participating by online with us. I recognize we have very busy schedules and lots of travel in the off season. So we're trying to announce these in far in advance as we can. A couple of them did kind of sneak up. So Mr. Pro Tem, you are recognized.
Yeah, Mr. Chairman, similarly, I think I got circumstances, but I was trying to get here, maybe got caught in traffic, but I too was listening in as well.
Well, we wrote
right.
you down as arrived at 2:57.
Yeah.
You were tardy.
I was
So
tardy.
we
I know I
you
got
were
here,
participating.
But I was, doing what I could to get here and listening on the way.
That particular meeting on May 23rd, we started at, we were planning to start at 2 in the afternoon, I think, because we knew we had some travel problems. So thank you for your efforts.
Yes, sir.
All right. Any other discussion? Is there a motion? We have a motion to approve and a second by Senator Dolezal. Any further discussion on the minutes of the May 23rd meeting? All right. All in favor of approving the meetings, vote aye.
Aye.
Any opposed? All right. Same thing now on the August 9th meeting, which was our last meeting. If anybody has questions about these proposed minutes.
Motion to approve.
All right, so again, we have a motion to approve. Is there a second?
Second.
Second by Senator Dolezal. Any discussion on these? All right, all in favor, say aye. Any opposed? All right, they are unanimously approved. We are also joined today by Mr. Josh Belafonte, who as legal counsel has been retained by the committee to represent our interest in certain litigation that it's already really been filed, but it's more to come, I think, in the enforcement of subpoenas before this committee. I will expect that at the conclusion of the public portions of this meeting and the public testimony, we may go into executive session to have him, under our attorney-client privilege, advise us as to the current status of any pending litigation. All right, at this time, then I want to have Mr. Stuart Morelli introduce himself and just give us an update on the sort of the legislative process here, the investigative powers of our branch of government, and the ability to have witnesses to testify under oath, and our issuance of subpoenas. As a member of the Legislative Council's office, you are assigned to this committee, and we appreciate your efforts in helping us behind the scenes be prepared and follow the appropriate procedures up until this date. And you shared with me this memo that was it's 13 or 14 pages long that was prepared some years ago by your office. If you would just kind of give us a general overview of the research and work that you've done and the big scope of things, the legislative investigative powers.
Yes, sir. So, as the chairman said, I believe each of you have a copy of the 2016. I've always called it a manual, whether you call it a manual or a memo. It is the research our office conducted some 8 years ago in outlining the legislative investigative powers, including the abilities to issue subpoenas and compel witnesses to attend. When you're looking through that, you'll notice that a number of citations go back to, of course, Mason's Manual on Legislative Procedures, which I may also be, referencing, in my presentation today. Mason's does a very good job of, outlining the various the powers of legislative bodies, as well as the procedures in them, and cites to, case law in states to support its positions. So as a general matter, it has been found almost universally by the various courts that have looked at the matter, including the United States Supreme Court and Supreme Courts in our sister states, that all legislative bodies have an inherent power to conduct investigations. As the Supreme Court reaffirmed, the United States Supreme Court reaffirmed in 2020, that power is inherent to the legislative process, as in it does not have to arise from a specific grant of statutory or constitutional authority.
This 2020 case would not have been in the 2016.
No, sir. And I'm going to provide some, that information on this case. It is the Trump v. Mazars case out of the United States Supreme Court in 2020. In the Mazars case, the Supreme Court did provide that Congress has no enumerated constitutional power to conduct investigations or issue subpoenas, but we have held that each house has the power to secure needed information in order to legislate. And they cited to a 1927 opinion of theirs, McGrain v. Dougherty. The Mazars case, Mazar court went on to provide the power of inquiry with process to enforce it is essential and appropriate auxiliary to the legislative function. Again, citing back to their 1927 case in McGann. The Mazars case then went on again to state, without information, Congress would be shooting in the dark, unable to legislate wisely and efficiently. As I said, in 2020, the Supreme Court was citing back to its 1927 precedent, upholding Congress's power. State Supreme Courts have held the inherent power of their legislatures to conduct investigations, going, I believe, as far back as 1824, when the Massachusetts Supreme Court, I believe, was the first state Supreme Court to address the matter. As I said, it has been a near universal finding that legislatures have this authority. The only dissenting view that I'm aware of was stated by Justice Thomas in the Mazars case. He did believe that the precedent relied upon by the Supreme Court and the other state Supreme Courts was misguided, but no other justices joined in that opinion. Other state Supreme Courts have continued subsequent to the issuance of Mazars to continue to also uphold state legislative investigative powers of their legislature. I will.
Was that an 8-1 decision then? Or?
Justice Alito dissented on different grounds. He did not join Justice Thomas's dissent, so it was 7-2.
Okay.
And just for the record, the Georgia Supreme Court has never addressed legislative investigations. It just has not been an issue that has made its way to the Georgia Supreme Court. So it does appear that there is virtually no case law directly on the ability of the General Assembly to carry out or to compel testimony and compel witnesses to appear before it and to produce documents. In addition to the near universal finding that legislative bodies have an inherent power, it has also been the near universal finding of the U.S. Supreme Court and other state Supreme Courts that the power to investigate is not only possessed by the entire legislative body, but also by its constituent chambers, and that those powers can be exercised by one chamber on their own. So bicameralism has never been found to be necessary to carry out an investigation, to compel testimony for a full chamber of a legislative body. And also, the courts have universally, when the issue has come before them, held that a legislative chamber is fully within its right to delegate its legislative investigative powers to a committee, including the power to compel testimony and subpoena documents. However, the case law is also clear that absent such an affirmative delegation, a committee does not on its own have any inherent power to conduct investigations. And the investigatory powers of a committee are limited to those that are specifically granted to it by its parent body. One area in which there is not a universal holding when it comes to legislative investigative powers would come to the ability of a legislative body or a committee of a legislative body to conduct its hearings and to compel testimony once the legislative body has adjourned sine die. There is a conflict between the state courts that have interpreted this matter. Some state courts find that it is perfectly fine for a subcommittee or for a committee to compel testimony after the parent body has adjourned sine die. Some Supreme Courts have found that it would require a joint resolution of both chambers of a legislative body to allow that to happen, finding that once the General Assembly had adjourned sine die, there would need to be some level of bicameralism for the investigative powers to be conducted. And some state Supreme Courts have held that such investigations are completely prohibited, based upon the rationale that since the investigative powers are auxiliary to the legislative power, and since a legislature cannot legislate once it is adjourned sine die, then the auxiliary power itself would disappear. Luckily, here in Georgia, we do have a constitutional provision that addresses the ability of the General Assembly to establish interim committees. Article 3, Section 4, Paragraph 4 of the state constitution provides that each house shall determine its rules and procedures and may provide for its employees. Interim committees may be created by or pursuant to the authority of the General Assembly or of either house. So the people of the state of Georgia have empowered each chamber of the General Assembly to establish interim committees as they so choose.
Let me hold up just to make sure we all understand this then. In the state of Georgia, it is in the Constitution that each body, the House and the Senate, may establish committees that's work may continue after sine die.
Yes, sir.
Okay. And so any of these other states that have varying decisions would be based on their statutory law and their constitutions.
Yes, sir, that is correct.
No Georgia court has ever held that our legislature doesn't have the authority to meet in the off season, as many of us call it, but when we're not in legislative session.
Yes, sir. That is correct.
That's why we have all these study committees that meet every year that are investigating and trying to find solutions to problems and formulate legislation.
Yes, sir.
Okay. And as far as you're concerned, does that constitutional provision also apply to investigative?
Okay, we're going to do a short pause for context. We are watching the special committee, the Georgia Senate. This is the committee that was formed to look at Fani Willis in relation to the Trump RICO case. They had subpoenaed not just Fani Willis to appear for testimony, but also a subpoena for multiple types of documents. So I did put it in the chat, but just I know a lot of people don't watch the screen. But they had requested, they'd subpoenaed any emails between Fani Willis and Nathan Wade over a 5-year look back period, accounting of any gifts. In general, I don't think that was limited in scope to just Nathan Wade, but specifically they also wanted a record or ledger of money and any items of value exchanged between Nathan Wade and Fani Willis in the course of their relationship. They also wanted to get more information on federal grants and how that money was spent, so they subpoenaed any records relating to that accounting. And they're also subpoenaing communication between any one of Fani Willis's staff, the White House, the DOJ, Congress, those groups relating to the 2020 election. And her attorney, she has several attorneys representing her, but her lead attorney is former Governor Roy Barnes. And his argument is that the subpoena is not valid and he's fighting the enforcement of it. So this guy that's been speaking, he's here to really advise and educate the Senate committee on the legislative subpoena power. What can we actually enforce? If she's not showing up, is there anything we can do? Because Roy Barnes, on the other hand, has made arguments, and maybe we'll see him today continue to make the argument that the subpoenas are invalid. They're too broad, they're not enforceable. So that's where we're at. We'll do 1.25 and get caught up. But I thought that was important. I see a lot of questions about what exactly is going on. So that's the short of it.
Authorities as set forth by Senate resolution. Make sure I remember the number here. We have this in the folders as well, 465.
I see no reason why that provision would not apply to a standing or a special committee as well. It would seem to be it would seem to be limiting the power of it would just, seem inconclusive that why an interim committee could meet, but a standing committee would not, when the Constitution has authorized a type of committee to meet in the interim.
Your legal opinion that we are authorized to meet in the interim?
Yes,
by the Georgia Constitution. How about under Senate Resolution 465? Does it specify that we are permitted to continue our meetings after signing day?
I don't believe it specifically states that, but it also, unlike the resolutions that would tend to create study committees, does not end date for the committee. A typical resolution committee, a study committee, talks about how those study committees tend to stand dissolved as of typically December 1st of the year they were created, absent any type of explicit date stating when the committee dissolves. The resolution would appear to indicate that this committee has the authority to continue to operate until the 158th General Assembly is sworn in, this being the 157th General Assembly.
Okay. I apologize for my interruptions, but I didn't want to forget them. So back to your presentation.
So, and this is kind of along the lines of, in addition to the constitutional provision, while there has not been any case law that addresses the ability of the General Assembly to conduct investigations, there have been, on, as far as I can tell, 4 occasions where the General Assembly or a chamber has created a committee to conduct investigations and to study the affairs of the state. And in all 4 of those situations, it does appear that those committees did carry out their powers once the General Assembly adjourned sine die. I would say the clearest example of this authority comes from 1871 with joint resolutions 7, 9, and 12 of the General Assembly. Both of those, again, were adopted by both the House and the Senate. They established various joint committees to investigate the issues arising of former Governor Rufus Bullock's administration. These resolutions specifically granted to those investigative committees the power to compel witnesses and subpoena documents. Then in 1896, the House of Representatives, and through a resolution, established a committee to investigate each department of the state government. The resolution was adopted on the day that the General Assembly adjourned sine die, so there was no way that that committee could have carried out its functions during the session. Based upon the House journals, it does appear that that committee did conduct extensive investigations in the interim in 1896. In 1897, the committee filed its report with the House, and the committee report and the minority report go on for about 86 pages. They provide a very in-depth, detailed examination of the affairs and operations of the various state departments. This committee apparently went to the offices of each state executive officer, inspected their books, investigated their practices. There is a in-depth discussion of the ability of the affairs of the Department of Agriculture at the time. It appears that the committee questioned the best practices the Department of Agriculture was carrying, not only in bookkeeping, but in contracting with various contractors. I believe it was to provide tags for seed oil. Not being an agricultural guy, I don't completely understand that. They also, there are references in the committee report to how they visited each of the state's hospitals at the time, commenting on even when they went to the school for the blind, that the dormitory for one set of students, the boiler room, was lacking adequate insulation around the boilers. So it was a very in-depth review, digging into the details and operations of the various departments of the state executive branch. And again, making comments on their bookkeeping, making statements on how much funds they had. The committee made a number of recommendations, both for potential legislation to address matters that they saw, as well as to recommendations on future appropriations, whether to increase or decrease the set levels that had been given to the various state agencies. I will note that the 1896 resolution by the House does not state that it grants the committee the power to compel witnesses, but as I said, they undertook an extensive investigation. The report makes no indication of whether or not the executive branch objected. So I cannot speak to whether or not they were forced in some manner to get the executive to comply, but the report is silent as to that matter. And then finally, at least in the past 100 years, we're getting up to, in the 1964 special session, the Senate adopted Senate Resolution 30, which established an interim committee to make a comprehensive inquiry into the Stone Mountain Memorial Association. I just discovered this resolution last night and was unable to get my hands on the Senate journals for the 1965 session, so I do not know what the report said. The 1964 resolution creating the interim committee to investigate Stone Mountain Memorial Association also was silent as to whether or not it delegated the power to compel witnesses. I was able to see that a number of bills were proposed and adopted in the 1965 General Assembly, revising various provisions of the law governing the Stone Mountain Association. So I would make the assumption that the committee did make some recommendations that led to that legislation. Enforcement of legislative subpoenas has also been a matter that the courts have been forced to address throughout the history of the United States. Going back to 1821, the United States Supreme Court in the Anderson v. Dunn case did find that each House of Congress did have the inherent power of contempt. In that case was actually a case where a gentleman was detained by the Sergeant of Arms of the House, and he had sued under habeas corpus to get his release. And the Supreme Court did uphold the finding, the Federal House of Representatives finding of contempt, the power to find him in contempt for refusing to come testify before them. In addition to the inherent power of contempt that most courts have found that legislative bodies have, judicial enforcement of subpoenas has kind of been the more modern practice if a state has not adopted a specific statutory procedure for enforcing its subpoenas. There are some states, like New Jersey, for example, has a very detailed provision for the enforcement of legislative subpoenas that ultimately can result in a person being held in criminal contempt if they fail to abide by a subpoena. In Georgia, we do have a couple of statutes on the books that do provide some degree of guidance for judicial enforcement of legislative subpoenas. One that I will not spend a lot of time addressing, nor does the manual, are the provisions in Title 28 regarding the House and Senate ethics committees. Those are really much more designed to carry out ethics investigations into members of the General Assembly themselves. Of course, we can get into that if anyone wants, but those provisions don't seem particularly pertinent to the present committee. In addition to those provisions, there are the provisions of OCGA 48-15-17 and 45-15-17 and 45-15-19. OCGA 45-15-17 provides the authority to the Attorney General to conduct investigations into the affairs of the state and does now provide procedures by which the Attorney General can compel people to appear before his or her investigations, subpoenaing those witnesses and subpoenaing documents as part of those investigations. In the event that the Attorney General is forced to enforce, if somebody refuses to comply with one of the Attorney General's subpoenas, the code provides that the Attorney General has the ability to go to the Superior Court of the county where the person to whom the subpoena was directed resides to seek judicial enforcement. OCGA 48-15-19 grants both the governor and the General Assembly the exact same authorities that are granted to the Attorney General in 48-15-19. While these statutory provisions do exist both in 48-15, both in Title 45 and in Title 18, they in no way override the General Assembly's inherent authority to conduct investigations or its inherent authority to carry out contempt procedures or its inherent authority to attempt to enforce its subpoenas. Article 3, Section 6, Paragraph 3 of the state constitution provides that the General Assembly shall not abridge its powers under this constitution. No law enacted by the General Assembly shall be construed to limit its powers. Therefore, the provisions of Title 45 and Title 28 are not limitations upon the General Assembly's power. They are additions to its inherent power and have probably been enacted to provide some guidance to the judiciary if the General Assembly is ever in need of its assistance in enforcing its subpoenas. Absent some sort of statutory provisions for the courts to refer back to, it would appear, and this has been the case in some of the older case law from other states, is that the courts are then forced to resolve disputes into legislative subpoenas using their equitable powers. So it just, at that point, it gets much more complicated for the courts to determine those matters absent some sort of statutory guidance provided. One area that is not addressed in the manual, but I felt needed some updating, especially in light of the Mazars case, are questions regarding separation of powers. And the Mazars case does lay out that courts, when considering legislative subpoenas, in certain cases in Mazars case, the president, need to show some heightened concerns to recognize the separation of powers. However, one thing that the Mazars case is very clear about is that it is limited to issues regarding congressional subpoenas to the President of the United States. As the Mazars court says, the president is the only person who alone composes a branch of government. It goes on to state, the interest of the man is often connected with his constitutional rights of his place. A balanced approach is necessary, one that takes a considerable impression from the practices of government. Courts must perform a careful analysis to take adequate account of the separation of powers principles at stake, including both the significant legislative interests of Congress and the, quote, unique position, unquote, of the president. So it would appear that the Supreme Court in the Mazars case, when they're setting these heightened standards of separation of powers, is designing that to specifically address the unique arrangement in the federal constitution where the president is the executive branch under, I believe, what is generally called the unitary executive theory. Two state Supreme Courts, as far as I'm aware, well, two state appellate courts have addressed the Mazars case and how it applies to state separation of powers issue. The first court case was the Montana Supreme Court, and I can give you all the citation for that case if you give me a second. Sorry, there we go.
Chloe Albert's Revenge says, Cat, he looks like Jeff, Legal Vices. He just needs a hat. Is Jeff live right now?
McLaughlin v. Montana State Legislature. In that case, the Montana legislature had subpoenaed the court administrator to request all emails that the court administrator had with the various judges of the Montana judicial branch to investigate whether apparently the Montana legislature had been considering some legislation regarding, I think, judicial compensation or some such. The judges circulated a poll amongst themselves, and the legislature was interested in the results of that poll. Ultimately, the Attorney General of Montana, challenged the legislative subpoenas, and the Montana Supreme Court did find that separation of powers in that case did require, and citing favorably to the Mazars case, that the legislature had exceeded its authority. Ultimately, the Montana Supreme Court found that Montana, similar to Georgia, has a procedure for judicial punishment, and that the alleged purpose of the subpoena was to investigate whether or not the judges had complied with the Open Records Act, and the Montana Supreme Court determined that that was not a function of the legislature, since there was an established procedure for the punishment of judges. The Montana Supreme Court found that the resolution setting out, or the subpoena issued by, it was, I believe, the standing judicial committee of the state.
Oh man. Hold on, I just pulled up a picture of Jeff Legal Vices, and now I'm making the Senate hearing buffer. My
Did
bad.
not properly detail a legislative purpose beyond seeking to see if the judges had complied with their Open Records Act. The other state appellate court that has addressed the Mazars case would be the Commonwealth Court of Pennsylvania, which I believe is their intermediate appeals court. The Pennsylvania Commonwealth Court in Costa v. Ward found that Mazars was not applicable to an issue arising when the Assistant Secretary of State of Pennsylvania attempted to quash subpoenas issued by their state Senate. The Costa Court, the Pennsylvania court, did find that the Mazars case was limited in scope to the specific unique role that the president has in the federal system. However, we also have a Georgia case, which is not directly on point, but it does address the issue of separation of powers when it comes to governmental investigations. In 1975, the Supreme Court issued an opinion in Dean v. Bolton. In the Dean
Legal
case,
Vices on the
the
screen. That
lieutenant
looks like
governor
this guy
had
speaking.
requested the governor to request the attorney general to conduct an investigation into the travel and expense accounts of a state senator. That investigation was conducted under the previous version of OCGA 48-15-17, it occurring before the OCGA was codified in 1983. I don't have the specific site. The language, though, the statutory language had not significantly changed in that, in that period of time. The senator challenged the investigation on the grounds of the state's separation of powers clause, constitutional separation of powers. The Georgia Supreme Court went on to provide, let it be sufficient here to say that this constitutional provision does not prohibit a person in the executive branch of government or a person in the legislative branch of government from investigating the official conduct of any person performing duties in any branch of government. The General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. So,
But hold on right there. That sounds directly on point, if you ask me.
it was not directly arising out of a legislative subpoena. It is directly on point to the statutory provisions that the General Assembly has and were cited to in the resolution establishing this committee.
And those are the same statutory provisions recited in our resolution forming this committee
Yes, sir.
or their predecessors.
Yes, sir.
would you give me the citation to that case?
Yes, sir.
again?
I'm sorry.
called Dean versus Bolton.
I've been a bad attorney and not giving you the sites.
You got a whole bunch of attorneys on here, and you got a couple of non-attorneys that are as smart as.
And I can provide copies of any and all of these cases to any members who wish them. The citation for Dean versus Bolton is 235 Georgia 544. And again, it was a 1975 case.
Yeah, all right, so that's Dean versus Bolton. 235 Georgia 544.
Yes, sir.
All right, so would you read that holding one more time? Because it sounded like it said that the executive branch, Attorney General in that case, did have the authority to subpoena records concerning improper conduct in office of a state senator, dealing with the travel and expense reimbursements.
Yes, sir.
And that same code section that gives the Attorney General that authority is what we're traveling under here, that gives the same powers that the Attorney General has to the state legislature.
Yes, sir.
Am I right?
Yes, sir.
Would you read the holding that you just read us again?
Yes, sir.
Okay, thank you.
Let it be sufficient here to say that this constitutional provision does not prohibit a person in the executive branch of government or a person in the legislative branch of government from investigating the official conduct of any person performing duties in any branch of government. The General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations.
Okay, so what we're doing is constitutional.
Under the Dean holding, it would appear so, yes,
And
sir.
that's a holding that's interpreting the Georgia Constitution.
Yes, sir.
And our separation of powers allows the legislative branch to investigate other branches of government, other individuals and their conduct in office.
That is that is definitely what can be taken from the Dean opinion. Yes, sir.
Pretty much
well
the
as the
clear
inherent.
wording of it.
Yes, sir.
Okay. And that was the factual scenario in that case, was looking into the conduct in office of a state senator.
Yes, sir.
All right. That's the only Georgia Supreme Court case dealing with this separation of powers, whether the legislative branch can investigate.
Yes, sir.
Okay.
As far as it was the only one that I found.
Still good law now.
Yes, sir.
And there's no constitutional provision that has been changed that would change the circumstances from 1975 until today.
No, sir. I believe the separation of powers provision of the 1945 Constitution was carried over verbatim into the 1976 and 1983 Constitutions. The only potential relevant change is, of course, the addition I talked about interim committees, which was apparently an addition in the 1983 Constitution.
And that 1983 Constitution is the current version of the Georgia Constitution.
Yes, sir.
Okay. All right. So before you veer.
Well, I have now reached the end of my prepared
Okay.
notes.
We're going to get some more out of you then. Back to the United States Supreme Court. Of course, that applies nationwide, right? Those holdings.
Those holdings apply to the federal government because it is interpreting the provisions of the federal constitution as it applies to the Congress's power. Those opinions are not binding precedent on the states, but have largely been taken as authoritative precedent. But, as I, said when my discussion about the Pennsylvania court did not accept Mazars as binding precedent, whereas even the Montana Supreme Court, when the state Senate asked for a motion on rehearing, the Montana Supreme Court in their petition to deny rehearing did state that they were citing Mazars only as authoritative precedent, but in no way claiming that it was binding precedent upon the state of Montana.
So when we talk about the idea of legislative oversight, legislative investigations on the federal level, there's a line of Supreme Court cases that say this is an implicit or inherent power of the legislative branch, that you have the power in order to do your job of passing laws in the public interest, creating public policy. You occasionally have to investigate. Similar to when our committees meet during session, we routinely have hearings and have presentations by the author of a bill and any other interested citizens giving pros and cons of the bill, right? And that's necessary for the legislature to do this investigation, to do their legislative duties.
Yeah, yes, sir. The general view is that the investigative power has to be inherent to the legislative process because, again, as the Supreme Court recited in the Mazars case, without information, a legislative body cannot properly legislate, as I believe the U.S. Supreme Court said they'd be legislating in the dark.
Very similar to probably the seminal United States Supreme case creating judicial review, Marbury versus Madison. All the lawyers on this panel, they graduated law school, so they know that one. The United States Constitution never says the United States Supreme Court has the power to strike down a law as being unconstitutional. But
Correct.
they stated that power because it was implicit, inherent. Otherwise, you're a ineffective branch of government as the judicial branch if you don't have that inherent power to set the rules, what is and is not constitutional, right?
Yes, sir.
Same type of principle here on legislative investigations, that is an inherent legislative authority, whether the U.S. Constitution says it or not.
Yes, sir.
But the Supreme Court, it says they got it,
Yes, sir.
even though it's not articulated in the Constitution.
Yes, sir.
Any reason that should be different at the state level?
No, sir. In fact, some of these, what I've seen in some of these state Supreme Court rulings is they find that inherent authority can also be justified under a separation of powers.
Okay.
Because absent, the ability of the legislature to investigate on its own, would be highly dependent on information provided to it by the executive.
So even if Georgia's Constitution did not give an investigative power to the legislature, it would be implicit if in keeping with the United States Supreme Court's interpretation of the separation of powers.
Yes, sir. Yes, sir.
And the provision you read out of the Georgia Constitution, does it essentially give us that constitutional authority?
The state constitution does not give an explicit power to it and to conduct investigations. It does specifically authorize the provision I cited specifically gives the General Assembly and its chambers to establish interim committees to conduct, activity once they've adjourned sine die. Since the General Assembly cannot legislate post sine die, really the only activity those committees could take would be studying or investigating.
And that's what we're doing, studying and investigating here. The Dean versus Bolton case was a Georgia Supreme Court that says the legislature does have investigative powers.
Yes, sir.
Okay. So even if it's not specified verbatim in our Constitution, our courts have followed the United States Supreme Court interpretations that the legislature has an inherent ability, power, authority to investigate.
Not in so many words, but I would say that your statement is correct.
Okay. And this committee, in our resolution that formed us, and I'm going back to Senate Resolution 465, says at line 81, section 4 here, the
Shout out to
chairperson
Classy
shall
Beats.
call all meetings of the committee.
Hold
Committee
on, you
may
guys.
conduct such meetings
one in
at
the chat
such
if you know
places
Classy
and at
Beats. Put a
such
2 if you need a
times as
link.
it may deem necessary or convenient to enable it to exercise fully and effectively its powers, perform its duties, and accomplish the objectives and purposes of this resolution. That in no way limits the meetings to just during the legislative session, does it?
I do not read any specific limitation.
It's whenever the chairperson calls the meetings and at any places and times as we deem necessary to do our job, right?
Yes, sir.
Okay.
Okay, so there is a
through
link to Classy in
I would
the
say
chat.
up through when
Make sure you
the
subscribe.
next General Assembly is sworn in on the second Monday in January 2025.
So to that point, we're no longer in office. The biennial is over.
Yes, sir.
Might be in office if we're lucky enough to be reelected and have chosen to run, but otherwise it'll be a new General Assembly then.
Yes, sir.
Okay. Is it your legal opinion that we are authorized to conduct investigations and hold meetings and take binding actions up until I guess that's the second Monday in January of 2025.
That would be when ultimately this committee disappears along with the 157th General Assembly itself.
And let me shift your attention a little bit to the resolution itself then. Because I'm looking at this as sort of three various grants of authority to this committee. Number one is this constitutional authority, whether specified precisely in the Constitution or just the implicit inherent powers that have been validated in the Dean and Bolton case, at least. Additional statutory powers under the statutes you've referenced. Those would be not limiting, but in addition to this inherent or implicit power. Right.
Yes, sir.
And then the powers given under this Senate resolution that was passed and became law authorizing this committee.
Yes, sir.
Okay.
All right, and shout out moment here. We're going to take a quick pause just to get caught up. I had dropped a link in the chat to Fani Willis and Roy Barnes' response on September 4th, saying why they thought these subpoenas were invalid. We can look at that after this Senate hearing ends, but I'll keep dropping the link in the chat. We also have a big shout out to Classy Beats, who is, a lot of you guys know Classy Beats. He's a great creator, tons of content, not just on YSL and court cases, but also really into music, if you can't tell by the name, and helps other music artists. He does a live review. He gives away Shure microphones. Really, really awesome stuff. So you got two different things going on his channel. Great, great creator. So we have dropped the link. Thank you, Factual Lie, and the mods. But make sure you're over there checking out Classy Beats, especially if you like the sound quality of good hearings, good streams. Great, great sound quality listening to Classy Beats. Appreciate you so much. He says, y'all better get the likes up and show some love. I appreciate you, Kat, and we'll def be catching the replay to hear your insight. Got you on the redirect. So we'll have a party today. We will have a party. La Mustache Wipe Gang says, this is a hearing to determine if DAs are immune. Yep, it's about the balance of, legislative power over, Fani Willis is a DA. What's the legislation currently that we have in the state? What does it say? What's the gray area? How do we figure out what to do from here? And Fani doesn't seem to be there to argue her case, but maybe we'll see Roy Barnes make a counter argument to what we're hearing now. So very interesting stuff. Big shout out to E. Capone, my fellow justice junkie. It's been a good time. Long time since I've seen you. Happy to see you. Chloe Albert's Revenge says, my illustrious job lost another police commissioner. I don't bother learning the names anymore. Yeah, a lot of turnover in a lot of these important positions. These jobs are just titles. PC, DA, CEO. Others do the work. They should all be replaced with, I think it's a dog, right? They'll do a better job. Thank you so much, Chloe. And yeah, it's, what's the quality of these organizations, these offices when the turnover's high? What's the quality of the people that you retain? Like, that's a major consideration. Turnover isn't just meaningless. Turnover is important. So great insight, and always interesting to look at, people resign, people get booted out, people quit because they hate it. And what does that mean for the stuff that's supposed to get done? Thank you, Chloe. And then Chloe, thank you again for pointing out that this man here, I gotta catch his name, looks like Legal Vices. That, seriously, great uncanny resemblance right there. Casey Dog says, I don't know how the mods keep up. Much appreciated with the green heart and the snake. Thank you so much for showing mods appreciation. La Mustache Wipe says, I show up earlier and more prepared for trial than DAs. And I think we've seen more preparation in this hearing than obviously we saw this morning with YSL and yesterday with YSL. So big, big contrast. Chloe Albert's Revenge gives us some insight here on Apple devices. So, you hear me say, I think with iPhones and Apple devices, you can't always find the way to become a member by clicking that little money icon near the chat. You usually have to click the join member link, which is in the description of the videos. But Chloe says it's weird, it's wonky. I have all the buttons on some channels, but not others. Just like some channels have more ads, just for our information. So good to know. So I guess, who's an Apple user in the chat and thinks it's weird trying to figure out how to become a member on a channel? I'm an Android girly, so I haven't run into the problem. But it just seems like a bad user experience when an Apple user is trying to use YouTube. And I hope they get it together one day. But thank you for the advice and guidance on that issue, that perpetual issue. Flashy Felix, thank you for becoming a member. And then Nick Starro, we gave some love to Nick Starro, but I'm going to remind everybody again that later today, Nick Starro will be doing his panel, and Nick Starro is also extremely close to 10K subs, which is long overdue. So if you want to tune into that panel or just give Nick Starro a subscribe, that would be awesome. Here's his link here. And what's the over-under on Fani being at Nathan Wade's place going, nobody can force me to come to a darn hearing? You guys can vote the over-under in the chat there. Thank you so much for showing love, Nick. See you later. La Mustache Wipe Gang says, someone's handle name here is Factual Lie. Yeah, it's so good. Shout out to Factual Lie. Mark in Texas says, important point, the Supreme Court of Georgia follows SCOTUS, which, in my humble opinion, honorable opinion, means these crazy Georgia RICO evidence rulings Page is leaning on are ripe for reversal. You know, I was thinking about this morning. What if this RICO case, it goes to appeal and it ends up dismantling the Georgia RICO statute and the way Georgia pursues RICO cases? That sucks for the defendants because that's a long road for them. But in the big picture, what if it dismantles the whole legislative enterprise around RICO in Georgia? It'd be really interesting. Great food for thought there. And then hold on, I see someone saying, I think Nick made 10K. He's close. He's really close to it. I think like with this chat, we could get him there. So, and heck yeah, you guys, shout out. These are all channels I love. Lurking in the Bushes. Uncivil Law does a ton of Supreme Court SCOTUS stuff, which is great to hear. I love listening to it. Legal Vices lives in Korea. It does some maritime law, but also covers popular trials. I think he's doing some Sarah Boone stuff. Law and Lumber and Runkle of the Bailey, I think a lot of people know, but they do a law show. I think Friday nights at 10 p.m. is usually when they start. Great channels, all of them. Like literally all four. Love hanging out with them. Okay, so we've got 114 to go. Heck yeah. We need to get you there. So guys, if you could just show Nick some love, he is so close. He could get there before this panel. And then let's see. And then we got a unnamed and unindicted gifting a membership. So we have another slime today. Thank you so much, unnamed and unindicted. And I also love that your picture is a cattail. So your cat is just unnamed and unindicted. And then we'll get back to this hearing, you guys. I'm also going to drop the link to Fani's response. I was in this stream. We'll hit the play.
In that, can I direct your attention to that resolution? It's in each person's folder as well. Okay. On page 3, starting at lines 45, I'll just read. Whereas such inherent powers include the authority to create special committees for the purpose of conducting investigations and to endow such committees with all the inherent powers of investigation possessed by the Georgia Senate, including the power to compel the appearance and testimony of witnesses and the production of records and the power to place witnesses under oath or affirmation. Does that language specifically give us the power to subpoena witnesses to testify before this committee?
Yes, sir. It would appear to me that it does.
And to produce records for our investigation in the course of our duties?
Yes, sir. That paragraph does appear to be an explicit delegation of the Senate's inherent powers to this committee.
Is this in any way inconsistent with any statutory authority in Georgia or constitutional provisions in Georgia?
It is not contrary to any constitutional provision, and because it is the inherent power of the body arising from the Constitution, I don't believe a statutory provision could conflict with it.
Okay. The resolution goes on in lines 50 to 54 to say, in addition to such inherent powers, Code sections 45-15-17 and 45-15-19 empower the General Assembly to make investigations into the affairs of the state and further authorize compelling the appearance and testimony of witnesses and the production of records, and grants the power to place witnesses under oath or affirmation and to enforce subpoenas issued pursuant hereto. Is this just an additional power to subpoena?
Yes, sir.
Okay, and that's what's contained in those two statutes?
Yes, sir.
Okay. Tell us about those two statutes.
Yes, sir. Again, 45-15-17 is the statute that grants investigative powers to the Attorney General that I talked about earlier, including the ability to subpoena witnesses and to compel the production of documents. It also does provide the procedures for enforcing those subpoenas, whereby if a person refuses to comply with the subpoena issued by the Attorney General is empowered to seek judicial enforcement of those subpoenas by going to the Superior Court of the county of the residency of the subject of the person to whom the subpoena was directed.
And does that statute give the legislative branch the same powers and authorities as the Attorney General?
OCGA 45-15-19 gives the General Assembly the same powers that the Attorney General has in 45-15-17.
So those powers of the Attorney General to subpoena and compel testimony or documents is granted to the General Assembly in 45. You got that?
15-19.
15-19.
Yes.
Okay. And that's recited in our resolution that formed this committee, that we possess those powers.
Yes, sir.
In addition to the power granted through the resolution itself, and in addition to our inherent constitutional powers.
Yes, sir.
So, okay. Do you have any question that this committee has the power to subpoena testimony or subpoena documents in furtherance of the duties set forth to this committee in the resolution 465?
No, sir.
Okay. Any other senators have questions? I want to recognize the minority party as our rules provide to ask any questions. And Senator Jones, I'll look to you since you've done that. Since this is more of a presentation than sworn testimony, since he's counsel for our committee, I'm going to defer to you. But then if other committee members have specific questions, unless there are objections, we'll do that.
Right.
You have the floor.
I just have
Make sure
one.
you lit up. All right.
And that was the 4 instances that you gave about them, I guess the committee doing an investigation after sign or die. Can you kind of go back into that a little bit more? And it was the last time that happened was in 1964. Is that correct?
Yes, sir. The last time that I'm aware of a committee being created, a committee being created specifically to investigate a specific part of the state government was the 1964 resolution that the Senate did regarding the Stone Mountain Association.
And obviously no one has never come up. So this would be a case of first impression, I guess.
Yes, sir.
If it goes to court. Have anyone given any legal opinion about why they may believe that they are not subject to subpoena? Like, what's the counter argument? I'm just curious.
My understand, they're people who have court, like in the Montana case, the court administrator did argue that the subpoena went beyond a legislative purpose. There are limitations that a legislative subpoena must be in furtherance of a legislative purpose, and so there are many instances where people have challenged a subpoena issued by a legislative body, alleging that there is no legislative purpose behind this investigation.
And do you think that would apply in this case? Or of course, we don't really know, do we?
The resolution, under my understanding of the resolution, is that is designed for this committee to investigate potential legislation to be introduced regarding potential matters of appropriations regarding district attorneys, like the contracting procedures, especially in regards, I think it specifically references hiring special prosecutors. So my understanding of the resolution is it does outline a legislative purpose for the committee.
Yeah, I think so. Thank you. That's all.
And doesn't it specifically direct us to investigate the conduct of District Attorney Willis's alleged conduct?
Yes, sir.
So it wouldn't be out of line to invite or to compel her to appear before this committee then, would it?
Not if this committee believes that is in furtherance of its legislative purposes.
Seems it's almost fair to give her a chance to defend herself and give her side of the story. Agreed or not?
I have no position on that, sir.
That's the lawyer answer. That's good. And that's what we pay y'all the big bucks for, is just give us impartial advice. Thank you. Other committee members with questions? Senator Tillery, I'll recognize you.
Thank you, Mr. Chairman. Thank you, Mr. Morelli. I have one question. I heard you read the Dean opinion that talked about let it be sufficient to say the constitutional provision does not prohibit a person from the executive branch from investigating, or from the legislative branch from investigating. Then that, I want to go to that next paragraph though, because you've studied this more than we ever will. The sentence that said the General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. In your research, just I understand where you've tied this up, but I want to look at the little hole here and say, have you in your research found any statutes or procedures that the General Assembly, since this decision, have enacted that would limit that power that you discussed that Dean appears to give?
Yes, sir. Actually, following the issuance of Dean, or almost concurrent potentially, the predecessor to OCGA 45-15-17 was amended in 1975. And one of the provisions added at that time, and I'm going to pull that stat, was a subsection D to OCGA 48-15-17, which specifically provides that nothing within that code section shall authorize the Attorney General to investigate members of the General Assembly during session.
During session.
Yes, sir.
So if we carried that same provision over to 48-15-19, then
that statutory provision, of course, could not, but the Constitution does grant each chamber of the General Assembly the ability to, govern and investigate. There is an inherent and constitutional power of each chamber to govern the conduct of its members.
gotcha. So that whole would not be able to eviscerate the power that it appears that we have through the Constitution and then through the progeny of Dean.
Correct.
Gotcha.
And further backed up by the provisions of the ethics provisions of Title 28, which were subsequently added much more, I think in, the early 2020s, the detailed ethics provisions that give a second independent statutory procedure for the ethics committees to issue subpoenas.
Hey, Nita Vita, good to see you. And I see you're joining late. What's happening? I just saw a few other people join. If you're looking for the YSL trial, we covered today's hearing for day 129 at the beginning of the stream. They recessed early. It wasn't that exciting. It was just nobody had anything that they could work on productively while the jury was out. So after a couple repeated questions, Judge Whitaker's like, all right, well, why don't you guys take this time to get work done? So they recessed for the day. And at 10 a.m. Eastern, about an hour ago, we turned over to start watching this Georgia Senate committee, special committee. They tried to subpoena different records as well as testimony from Fani Willis. And the man that we're mostly seeing speaking here, sitting here, is giving us insight, giving us existing legislation. He's also making references to what exists in other states to help fill in gaps. But the real issue at heart here is balance of powers, executive branch versus legislative branch, because prosecutors fall under the executive branch. So Fani Willis as the DA is over here. And if we're trying to subpoena as this branch, as the legislative branch, over in the executive branch, how much power do we really have? What's established in existing legislation? What is a gray area? What don't we have a procedure for? Because this branch right now is fighting the subpoena and saying it's invalid. It's too broad. It should be unenforceable. So we're watching this guy give some information so they can hash this out. How much can they actually enforce Fani Willis to sit down and testify before the committee and produce requested records? So that's where we are. And then also Mark in Texas, thank you, says, Fani apparently tried to quash her subpoena and every Fulton County judge recused, including Granville Glanville and Page. Maybe this was the meeting Page, Page attorney yesterday. I'm missing the last part there, but I think what you're saying, I saw even Scott McAfee recuse himself. So it'll be interesting to see what happens with that. I'll look up some news articles while we're playing this.
All right, other questions? I would, Mr. Leader.
This will be short. Stuart, thanks for being here today. It's great to see you this summer. OCGA
Thank you, sir.
55, 15, 17, and 19. When were they adopted into law and by which governor was it signed?
I don't know which governor. They were initially enacted into law in, I do have that before me if you will give me a second. It was in the 1950s. I do know that much. I don't, I want to say 57. I don't know who the governor was.
Any stories behind the reason for the laws at the time?
My research did not delve that far. I've saw the statutes are on the books, and in preparing for today's meeting, I went and pulled when they were initially enacted,
Okay.
but I did not do any further research on what may have created them,
Thank you.
caused them.
All right, I would advise all committee members that Mr. Morelli is available to all of us if you want him to follow up with any further cases or explanation or updates. You're all free to contact him directly. He is assigned to this committee as a resource to each committee member. The memorandum, I call it, they call it the manual on investigations and subpoenas was done back in 2016. We each have a copy of that in our folders, and it sounds like he's done some updated research. I just have one more question. We need to move on. That Supreme Court case, is it Mazars that you're saying?
Mazars.
Mazars. Is that one where the president was objecting to subpoenas from some congressional committee?
Yes, sir. A variety, I believe multiple committees of, I think it was the House. That was the case where they attempted to get his bank records. Mazars USA was one of the accounting firms, I believe, that personally worked for President Trump and his businesses. One of multiple, I believe, House committees attempted to obtain documents from them.
So they objected to the
President Trump objected to his bankers releasing the documents. So
did the Supreme Court force them to produce the documents in
the Supreme Court overturned it, both that I believe there were cases both before the U.S. District Court for the District of Columbia and some in the Southern District of New York. Both of those trial court levels did go up to the relevant courts of appeal. Both the DC Circuit and I believe the Second Circuit upheld the subpoenas. The cases were merged before the U.S. Supreme Court, and the Supreme Court found that both the various courts of appeals and district courts did not sufficiently consider separation of powers issues relating to the president, remanded the matters back. I believe ultimately the various trial courts and courts of appeals allowed the committees to get some documents, but not as many as they had initially been seeking.
Yeah, and so the limitations on those subpoenas were due to the presidency, not other government agencies.
It was based upon the finding that a legislative subpoena on the president's personal documents so interfered with with the entirety of the federal executive branch, because under the unitary executive theory, the president is the executive branch.
So is this when they were trying to get his tax returns?
There is separate case law on that, that did go up. I believe they did get those. Those are based on statutory grounds.
Tax returns. Senator Dolezal, do you have a question?
Just really one quick question. Mr. Morelli, would it be accurate to say that this February 26th document it essentially serves as a basis for the authority delegated to this committee in Senate Resolution 465?
I mean, it is intended, the reason I call it a manual is because it was intended by our office to be a guide to members and committees of the General Assembly on how to carry out investigations if they wished.
Is there anything that you've seen in Senate Resolution 465 that's in conflict with either the manual or anything that you have since discovered in your legal research, whether it be in Mason's or previous court precedent?
No, sir.
Thank you.
All right. Thank you for being with us.
Yes,
Don't
sir.
leave us, but go back to your role here behind the scenes, advising us and watching. And if you think of additional information or new cases come to light that you think will be educational to our committee, please present those to us along the way.
Yes, sir.
Okay. Former Secretary Cook, please come forward. So good to see you again. Thank you.
Now get out of your way. Do you want me? I mean,
No,
the chairman has dismissed me, but.
you're not dismissed. You're just taking off the hot seat. If you want to sit up there, you're welcome to, because you guys are both just full of knowledge. That's good for us.
I'm gonna go back to my preferred spot, hiding in the corner.
All righty. We do. We do. You'll raise your right hand. I'm gonna swear you in for the committee. You swear the testimony you'll give before this committee will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
All right. Please state your name, your previous position, and tell us what you're doing now in retirement.
I wish I could get to retirement. I'm almost there. My name is David Cook. I am the former Secretary of the Senate. I am received my law degree from the University of Georgia in 1982 and have been associated with the Senate actually going back to 1977. And the Dean case that you were talking about earlier, I remember very well. It was my first year as the reading clerk for the Georgia Senate when Roscoe Dean was tried on my birthday, January 27, 1977, in front of the Senate for a contempt proceeding. So I was kind of chuckling when that case came up. But I've been associated with the Senate in one way or another for a number of years. I was Secretary of the Senate for the last 11 years and retired at the end of last month.
In your role, you have been a great guide to the Senate and the Committee on Assignments and other senators that have had procedural questions and issues, and you've been a great help to me, providing me just binders full of information, especially on how investigations have been conducted by legislative branch at all levels of government. So I wanted you as sort of a subject matter expert to tell us your thoughts today. Just give us your preliminary reviews and talk to us about the power to investigate of the legislative bodies, the Senate in particular.
Good. Well, thank you. I think the question before the committee obviously is, does the committee have the authority to investigate, to subpoena witnesses, and to compel production of that testimony or of documents? And I am of the opinion that the Senate clearly, and that this committee clearly has that authority. I'm in agreement with counsel who just testified here. I think he did a good job of laying out the law regarding the power to investigate. I want to come at it more from a parliamentary law, parliamentary procedure standpoint, but there's no way to separate those two out. They are both intermingled. So Stuart may have some comments on what I may say, or I'm going to provide some of my understanding of what I think the law says. But I'd like to start to basically give you what I think is an analysis from the viewpoint of parliamentary law and procedure as to why this committee does have the authority to do the investigation, to subpoena witnesses, and to enforce those subpoenas. I would first touch on a few principles of parliamentary law and then move on to our rules of procedure, parliamentary authority that has been adopted by the Senate, and hopefully demonstrate that this committee was one properly created, that the subject matter of the investigation is legitimate, that the committee has the power to meet during the interim, which we talked about a little bit, that the committee has the power to subpoena the testimony of government officials and to enforce those subpoenas. So before I begin on the parliamentary path, I think it's fundamental that we tip the hat to the 100 or more years of U.S. Supreme Court case law that says a legislative body has the power to investigate. I don't really to compel that. And I think the contempt power of the Senate, for example, provides some limitations, but there are other avenues to enforce subpoenas as well. So I think the analysis Stuart gave regarding the inherent powers of the Senate is very important. It's what most everything that we're talking about today is based on. Mason's manual, which you referred to a little bit, is recognized as the modern day parliamentary procedure manual for state legislators and legislatures, and is for the Georgia Senate. It's actually interesting. There have been 3 iterations of this manual. The very first one was by Thomas Jefferson when the country was instituted, called Jefferson's Manual. And out of that arose Cushing's Manual, which was used in the 1850s. And in the early 1900s, the state of California, Paul Mason, developed a very robust manual of legislative procedure, and it evolved into what we have today as Mason's Manual of Legislative Procedure. It's the authoritative manual on parliamentary procedure for state legislatures.
Is this the one that the National Conference of State Legislatures has adopted?
That's correct.
Yeah.
California granted NCSL, National Conference of State Legislatures, the actual rights to this in the 1980s. And since then, NCSL, they have a committee of parliamentarians that sit on this, and they update it every decade. So the most recent edition is the one that was updated in 2020.
Tell the committee and the public that's listening to you what NCSL stands for, what that organization is.
NCSL stands for the National Conference of State Legislatures, and it is a national association that is comprised of, to my knowledge, every state legislative body in the United States. And it draws on the expertise of members of the legislature and staff to help the state legislatures perform their functions as legislative bodies.
Well, it just so happens that Senator Kennedy and myself were at their national convention this summer.
Mm-hmm.
And there was a session on, I believe it was titled, Everything You Want to Know About Legislative Subpoena Power. 3 different states had presenters, and all unanimously said their states had upheld the power of the legislature to do investigations and use subpoenas. It's funny that that issue happened to be, addressed this year, but it was certainly reaffirming to us that all the states claim this power and exercise, and it's been upheld.
Right.
Back to Mason's.
Yeah. And to my knowledge, there's been the power to investigate is derived from the grant of legislative authority that has been given to the General Assembly by the Georgia Constitution. And everything kind of derives from that legislative power. The interesting thing about Masons, the good thing about it is that when you look at our rules, Senate Rule 10-1.5 provides that when any question that's not provided in our rules, which arises and not provided in these rules, the same shall be controlled by the most current edition of Mason's Manual. So the Georgia Senate has adopted by its own rules everything that's in Mason's Manual. Obviously, there will be a few things that are a little inconsistent, and where we are more specific on it. For example, there's some
And guys, I see
question
you guys
about
asking about a
whether you can meet
mistrial.
during the interim, but we have a Georgia constitution.
Just to clear that up, because this isn't the first time I've seen someone mention it, I know nothing about a new motion for a mistrial, so I'm not exactly sure where that's coming from. If I'm wrong or out of the loop, let me know, but just clearing that up. The court is just in recess because there's an issue with the juror, maybe a sickness, and they tried to have a productive hearing on evidentiary issues with the attorneys today, but nobody was really prepared to deal with anything. So they are in recess until Monday at 8:45 a.m. So that's what we got. That's what we got.
Constitutional provision that allows us to do that, which would override Mason's manual there. So we've adopted Mason's, and we'll be citing that throughout. Both, I think Stuart cited it, and I'll certainly be citing it. Before we get into the substance of the rules, I think it's important to touch on how rules of procedure are applied, and Mason's does a really good job on it right at the beginning of Mason's. In section 4, it puts it pretty succinctly. Mason says that the rules of parliamentary procedure are derived from several sources and take precedence in the order listed below. Those principal sources are, number one, any constitutional provisions. So if you're looking as to how the legislative body should act, constitutional provisions and judicial interpretations are paramount. The next authority are the rules of the Senate that we have adopted. The third authority is, what is our custom? What precedents have we had? How do we normally operate? And we have several ways that we operate that involve precedent and custom. Following that, in the level of authority, are statutory provisions. So in terms of procedure, our Senate rules can trump statutory provisions regarding procedure. Then the adopted parliamentary law, which is Mason's, and then fundamental parliamentary law, which really is pretty succinctly due process requirements that are required for any legislative body, and we're all lawyers are familiar with it, with due process in court, notice and opportunity to be heard, those kind of things. So Mason's is an important part of the Georgia Senate's parliamentary rules. I'd like to take just a minute to talk about committees, because that's what we're talking about here. There are really three types of committees. One are standing committees. They're provided for by our rule, section in Rule 2-1.3. And the purpose of standing committees is to look at issues that we know are going to be continuing. You have public safety, you have judiciary, you have government operations. We know that there are going to be all kinds of issues that occur during the session every year, year after year, that require the establishment of a standing committee to look at those issues. This committee is not a standing committee. The second type of issue, or committee rather, is conference committees, and those committees are created for the specific purpose of resolving differences between the houses. And you all are familiar with those on the last several days of the legislative session, where we have conference committees meet and work out disagreements between the House and Senate. And the third type of committee are called special committees. And special committees are created for the consideration of a specific task or duty, or to look at a specific issue, or to perform a specific function. These committees can also be named ad hoc, investigating, select, or study committees. We refer to them a lot as study committees here. And special committees are created by a resolution. Either by resolution, they can be created by a motion from the body. In this particular case, SR 465, the resolution that created this committee, was established by a vote of the Senate. Senate Rule 5-5.1 requires 29 votes to establish this committee and pass that resolution, and that occurred in the 2023 session. So the committee was appropriately established as a special committee of the Georgia Senate. So what are the committee powers? So the creation of a committee is authorized, as I said, by a resolution. And I think it's clear, I've kind of refer to Masons here a little bit and quote them. The Masons provides that the legislature may proceed to make investigations with its authority by authorizing committee of one or both houses. So there's been some question of whether the Senate can act without the House, but Masons clearly says that either house can establish a committee for purposes of investigations. Masons also says that the right to investigate any lawful matter is a right separate and distinct in each house and may be exercised through a committee. That's Masons 7795-11. So the creation of the committee, I think, was done in accordance with statute, in accordance with rules, but it was also done in accordance with our precedents. And Stuart touched on one of those going back to 1871. I think I'm not familiar with that one, but I am quite familiar with the 1964 Senate resolution that created the Senate Committee to investigate the Stone Mountain Memorial Association's Senate Resolution 30. It's actually created during the special session of the Georgia Senate General Assembly in that year and issued a report back, I believe, in the next year. So the committee was, I think, properly established under our rules and under precedents. I think it's also important to note that committees have to be viewed as agencies of the creating body, that this committee is an agent of the Senate. And any committee can exercise only those powers that are delegated to it by the Senate. The corollary of that is that any powers that the Senate does delegate to the committee may be exercised as fully by the committee as it could by the Senate. There's U.S. Supreme Court case law on that, and certainly Masons provides the same thing, Masons 795-5. So the powers granted this committee are broad, and you touched on them earlier, and I think it's important to refer to the resolution. The resolution specifically gives this committee the power to investigate, and specifically in the resolution to investigate the office of the Fulton County District Attorney and the conduct of the Fulton County District Attorney. Masons Chapter 74, is several pages long, goes on at length about the legitimate powers to investigate of a legislative body. And it's clear from our rules and precedent and case law that the subject area of this resolution is within the scope of the Senate's authority to do that investigation. For example, Masons provides that, quote, an investigation into the management of the various institutions of the state and the branches of the state government is at all times a legitimate function for the state legislature. The U.S. Supreme Court case that Stuart referred to, McGrain versus Dougherty, holds that an investigation into alleged malfeasance is, quote, plainly the subject on which legislation could be had and would be materially aided by the information which the investigation was calculated to elicit, end quote. The U.S. Supreme Court in Watkins versus U.S. said that Congress's power to investigate is at its peak when the subject is the alleged waste, fraud, abuse, or maladministration within a government department. That's Watkins versus the U.S. 1957 case. So the subject matter, I think, of this investigation and the authority of the committee to do it, I think is appropriate. Second, the Senate specifically delegated to this committee the power to issue and to enforce subpoenas. The resolution states, quote, for the purpose of conducting an investigation as provided herein, The committee shall have the power to administer oaths, to call any party to testify under oath at such investigations, to require the attendance of witnesses, production of documents, books, records, and papers, and to take the deposition of witnesses. The resolution goes on further and says, for such purposes, the committee is authorized to issue subpoenas for any witness or to compel the production of books, papers, and records, and is further authorized to undertake such actions as may be necessary to enforce such subpoenas in case of refusal to obey. So I don't think there's any question at all that there's been a full grant of the Senate's inherent power to this committee to investigate and to do whatever it deems necessary and proper to compel the production of testimony and documents. Further, SR 465 specifically grants the committee the authority to meet at such places and times as it may be necessary or convenient to fully exercise and effectively use its powers to perform its duties and accomplish the objectives of the purposes of this resolution. It's line 82 of the resolution. I think this language, as we touched on earlier, is broad enough to include the authority to meet during the interim, which is specifically authorized by the Georgia Constitution. Finally, SR 465 specifically authorizes the committee the power to enforce its subpoenas. The resolution states that the committee is further authorized to undertake such actions as may be necessary to enforce such subpoenas in cases of refusal to obey. The lines 77 and 78 of the resolution. So I think this is an interesting area that people don't, the next area, which is how do we enforce subpoenas, is where people get sidetracked just a little bit. And there's a little bit of a nuance there. I think there are three areas or three methods by which the Senate, and by virtue of its delegation, this committee can enforce its subpoena powers. And the first is by contempt. And that is set out in the Georgia Constitution. And there are some Article 3, Section 4, Paragraph 8. I think there's some limitation in that constitutional provision when you're trying to enforce a subpoena by virtue of the contempt power that's set out. There are different ways to enforce subpoenas, but the contempt power is one. And I think the contempt power can only be used during a legislative session. And it gets into the nature of how does a legislative body use its inherent contempt power. They get the sergeant at arms and they issue an arrest warrant, and the sergeant at arms, which has been in some of the cases and some of the very first uses of the contempt power of a legislative body, they go and arrest. I think the first one was maybe the Secretary of Agriculture, and they arrested him and brought him before the bar of the Senate, tried him and held him in contempt and imprisoned him. But that power to enforce the testimony through contempt is for punishment. And that power of punishment only lasts as long as the session as we are in session. So once we adjourn sine die, we lose the power to punish for contempt. But there are two other ways to enforce subpoena powers. The second method is through a judicial enforcement of subpoena powers. And I think there's no question, Stuart can talk more about this better than I can, but if the Georgia Senate has the inherent power to do investigations and the inherent power to get witnesses and testimony and information in order to fully inform its legislative process, and that process is stymied or objected to or thwarted in any way, I think the Senate, and by virtue of delegation of its power, this committee can walk over to the Superior Court of Fulton County, seek an injunction in equity. Stuart touched on it, try to seek a declaratory judgment action and an injunction in order to enforce what is its inherent investigatory and subpoena powers. That's called judicial enforcement. So I would say that is the second manner of enforcing a subpoena. And the third manner is by statute. And Stuart laid out what we have is in the statute 45, 15, 17, and 19. I guess the only comment I would have there's this statute, there's a statute that authorizes the Ethics Committee to enforce subpoenas, et cetera. But the inherent power of the Senate and its ability to delegate that power to a committee is constitutional. I don't think anybody would disagree with that. And clearly statutes cannot overturn what is a constitutional power. So I think anytime you're reading a statute where it says the General Assembly, et cetera, that has to be interpreted as supplemental to what are inherent constitutional authorities of the Senate and of this committee. So those statutes, I think, should be viewed as supplementing what the Senate's powers are, not as restrictive of it. So those are my prepared comments today. I'm happy to try to answer any questions that you might have on this, and happy to hear from counsel on anything that I might have said from a legal perspective that he might disagree with.
Mr. Secretary, you were the secretary at the time we issued these subpoenas for Fani
Yes.
Willis. In your opinion, are they in compliance with Senate Resolution 465 within the scope permitted under that resolution?
Yes.
Okay. Anybody else have any questions for Mr. Cook? All right. Thank you for being with. Wait, I do.
Oh, yep.
Senator Estevez, you're recognized.
Thank you, Mr. Chairman.
Sure.
And thank you, Mr. Cook, for laying this framework out. So my question is, are you aware of this power and even the enforcement procedures that you've laid out ever coming up before, used by this Senate body before?
And from a legal standpoint, I'm not aware of any, and Stuart, I think, can get more into that than I am. I'm not aware of, I think they're in the Dean case. There were several aspects of that, including a trial for a criminal trial. And there was a contempt proceeding in the Georgia Senate on that. And I think there were subpoenas issued pursuant to that, but I'm not sure. That would have been the only case. And then Stuart mentioned one, I think that subpoenas were issued back in the 1800s, but those would be the only cases that I'm aware of.
So 150 years ago, and then in proceedings against one of our own members.
Mhm.
Okay. Thank you.
Right. Thank you very much. Appreciate you being with us this morning and all your service to the Senate for many, many years.
So they are winding this down. We are going to look at the amicus
The
brief
last person
in
on
Steele
our
v.
agenda,
State.
of course, is the first person, Honorable Fani Willis. She has not appeared yet. I would ask the doorman, please check the hall to see if she has appeared before we adjourn.
So they're going to check. Put a 1 in the chat if you think they will not find her. 2 if you think they'll find her in the next 2 minutes.
All right, thank you. Then let's please note for the record that Ms. Willis has failed to appear in compliance with the subpoena and has failed to produce the documents requested by our subpoena for the production of documents. At this time, I want to let the committee know that we have hired Mr. Josh Belafonte to assist us in our legal enforcement efforts on the subpoena. And I would like for us to have an opportunity to be briefed by him. We have privileged communications with him under the attorney-client privilege. Our rules do permit, I think it's Rule 5 of our committee rules, that we can go into an executive session or a session that is closed to the public. So that requires a majority vote of the committee. If anybody is interested in having a private conversation with our counsel to let us know where the litigation stands, now would be the appropriate time to move for that. I recognize Senator Kennedy.
Thank you, Mr. Chairman, for that. And I would move that we do pursuant to Senate Rule 1-5.1, as you just stated, have this committee move to go into executive session for the purposes of hearing from appointed counsel to advise us.
Is there a second? All right, we have a second. Any discussion by committee members on the appropriateness of that or the desirability to have a private briefing? All right, all in favor of the motion, say aye.
Aye.
Any opposed? One opposed. All right, at that time, then we will conclude the public portion of this meeting and we will stand adjourned as a public meeting. We will continue in a executive session to be briefed by our counsel on the current status of litigation concerning the enforcement of the subpoena. Thank you. We're adjourned.
Okay, so next thing we're going to do is toggle over and look at this new brief in Brian Steele versus State of Georgia. This is in relation to the contempt case that's in front of the Supreme Court of Georgia. It's docketed for October 22nd. There's already been one amicus brief filed. This is a new one. It was filed yesterday. And big shout out to both Thugger Daly and Beck. In this chat, she's Beck, but on Twitter, she is I Stand This YSLD. I'm going to get their Twitters for you guys. So we'll switch the banner so people know what we're talking about. A lot of audibles today because of that short court session with YSL. But if you're not already following the Honorable Thugger Daly, you should do so. Tons of great updates, especially on some things that might not relate to the court case itself. And then I Stand This YSLD. Also totally worth a follow. If you're paying attention to this chat, when I say I Stand This YSLD, I'm talking about Beck. So here on the screen. So thank you so much to both Beck and Thugger Daly for getting this briefing to us. We're going to take a look at it. It's going to be a good time. And also shout out to great food for thought. I hope you guys saw it while we were chatting about it in the chat. But Mark in Texas says, as I said yesterday in X, Sledge's plea deal is an arm's length transaction, so negotiation both ways. Both parties have inputs and changes were made. Contracts of adhesion are more like end user agreements and insurance contracts. So great conversation about kind of a nuance in law when you get to civil and tort and business versus criminal. And, I think it's really interesting to see people's stance, especially with Love trying to bring up number 8 again yesterday, trying to get Judge Whitaker to reconsider her ruling to deny the admission of these emails and the attached versions of the plea agreement into evidence for the jury to see. And, Love keeps pushing this issue as if there were no reason not to admit these emails. But I think a major problem here, it was negotiation both ways, but I think we're still lacking that signed proffer agreement. And now this is no longer Mark in Texas's opinion, or maybe it is, it's just not expressed in this super chat. But my own thoughts to add to what Mark in Texas is putting down here is, we still just don't have this signed proffer agreement. And whether the jury actually understands these nuances and these insights, I think what they get to take away is they heard like 2 days of questioning about this darn plea agreement and then the emails relating to this darn plea agreement. And what do you think the conclusion, the takeaway that a juror, if you were sitting there and didn't get to hear the evidentiary arguments, you didn't get to see the text of some of the plea stuff that can't get in, what do you think? Where do you think you would land on the credibility scale? And I think it's a big deal because it's not the first witness that we have this kind of plea deal thing with. It's just the first time we've called the attorney to come talk about it. So thank you so much, Mark in Texas, for all your thoughts and for your support of the channel. That girl Mia also said, I'm late, so I'm catching up. But since the dishonorable Love is absent, she's watching. So let's all say hi. So we did in all caps. Hello, Miss Love. Thank God it's Friday. Cat Nat Williams, Rico Brady gang. Cat, you the best. Shout out to that girl Mia. Thank you so much for the 5. Miss Ada, thank you for becoming a member. And ooh, as Satchel and Mark in Texas want to have a debate, I would love to see it. I would love to see it. I am all ears because I know I'll learn something from both of you about, an area that I'm not that familiar with. Super awesome. Totally support it. And did I get my banner changed for this amicus brief? Yes, okay. I'll make it bigger. So that way it can be followed along. Now it looks really long, but it's because there's like the transcript attached. I think it's 21 pages of actual writing. And, oh, actually I like doing this better. Print view. And here is the link to the document we are about to read. So again, shout out to Beck in the chat and to Thugger Daily for getting this to us. What a great hodgepodge day of all these different things. Now we are going to look at this. And you can see it was filed yesterday. It registered through at 4 p.m. And this is in the Supreme Court, State of Georgia. Brian Steele's the appellant and the State of Georgia is the appellee. This is in relation to the contempt. So, brief of Georgia Association of Criminal Defense Lawyers, so GACTL, as amicus curiae in support of appellant Brian Steele. So, namely writing this, we have new names. Well, we might know some of these names, but they're different from the names on the previous amicus brief. We've got Hunter Rogers, Maisie Lynn Bairton, Jessica Jones, Greg Willis. And, you know, they're going to give us table of contents. This is always how amicus briefs should be filed. What are you here for? What's your general argument? And we get a good summary from this table of contents here. So, one of the arguments is Attorney Steele was vigorously advocating on behalf of his client, and his refusal to violate attorney-client privilege is not criminal contempt. So that's one of the arguments we're going to see. And B, Judge Glanville should have recused himself from the contempt proceedings because he provoked the extraordinary circumstances giving rise to the alleged contempt and became personally embroiled with Attorney Steele. So if you ever want to get the top level, amicus briefs always should contain a table of contents like this, or they could be rejected. So let's get into it. And again, why this is so long, they have the June 10th transcript attached, as well as the supplement from Doug Weinstein, the supplement to Diamante Kendrick's motion for mistrial, which also contained the June 7th ex parte transcript. So this brief is going to look at both of those transcripts for the two different ex partes that we know about. Now we're going to skip some of the tables of authorities, but you can see how much case law goes into something like this. This is a whole page. And then we get a bunch of statutes that are going to be applicable, and then some others. And when you see stuff referenced like this, you know, this is usually highly credentialed legal analysis that we're referencing because it's almost like an expert witness when you see stuff under and other cited in an amicus brief. Now, they have to state their interest as friends of the court. Amicus means you're a friend of the court and you're filing this on interest, maybe not just of the defendant themselves, but of a greater principle, of a greater concern for society. So the Georgia Association of Criminal Defense Lawyers, we're going to call that GACTL for the rest of the document, is a private member-funded, is a private member-funded statewide organization, be careful about that word organization, comprised largely of criminal defense lawyers. GACTL has a particular interest in the proper application and development of Georgia's criminal law, particularly when it involves a defense attorney's right to vigorously advocate on behalf of a client. GACTL has a vested interest in ensuring that defense attorneys are not subjected to criminal sanctions for fulfilling their ethical duties. This includes the duty of maintaining the sanctity of the attorney-client privilege relationship and attorney-client privilege communications. Punishing an attorney for fulfilling their duties sets a dangerous precedent that could severely chill the defense bar's ability to provide competent and ethical representation to defendants facing criminal charges. So you can see right here from this paragraph, even though this is being filed kind of on behalf of the appellant, that party, which is Brian Steele, they're stating a broader interest. GACTL members strive to be vigorous advocates, and as the United States Supreme Court held in Maness v. Myers, 419 U.S. 449 and 1975 case, an advocate should never be subjected to the penalty of contempt for protecting a client's rights in good faith. GACTL firmly insists that all defense attorneys in Georgia must be free from the threat of contempt for respectfully and honestly disagreeing with the trial court, making a record, and refusing to breach attorney-client privilege. To hold otherwise, what's the problem if we don't do this and protect this? To do otherwise, to hold otherwise, would discourage defense attorneys from vigorously advocating on behalf of their clients and encourage judges to abuse their power. So this is our impetus. This is our why, our mission. This is particularly true when the attorney is trying to protect a client in the center of an important controversy with a determined judge attempting to impose his personal will on the attorney with whom he has become personally embroiled. Gachtel urges this honorable court to find that holding an attorney in criminal contempt for refusing to violate attorney-client privilege not only harms the attorney-client relationship, but also jeopardizes the proper administration of justice in all cases. So the ripple would go across the entire ocean. Now, factual background. So we're going to hear some things that are repeated, but remember the Supreme Court might not be aware of absolutely everything. So the factual background helps the the judges on the Supreme Court get a background on what was going on. It's the context within which they'll consider this amicus brief argument. Amicus adopts, it's amicus, whatever. I'm going to do that panel on pronunciations one day, I promise. The amicus adopts and supplements the statement of facts in appellant's brief. On Friday, June 7th, 2024, Chief Judge Earl Glanville advised all parties in open court that he would address whether witness Kenneth Copeland, here we're going to just call him Copeland, intended to testify the following Monday, June 10th, 2024. Judge Glanville told all parties to return at 8:30 a.m. on Monday, including Copeland's counsel. Judge Glanville did not take the bench until 11:52 a.m. on Monday, June 10th, and gave no explanation for the nearly 3.5-hour delay. Judge Glanville did not inform the defense, including attorney Brian Steele, counsel for Jeffrey Williams, of the existence or substance of that morning's ex parte hearing involving the court, prosecutors, Copeland's counsel, and other court personnel. And they cite the June 10th transcript. I think that's really to get us a listing of who was present. That's what they're citing here for pages 4 or 5. The court did not disclose Copeland's exculpatory statements made in chambers to the defense. So, Brady material. After taking the bench on June 10th, 2024, Judge Glanville called the roll and asked the state if there was anything he needed to take up before Copeland was called to testify. And then the state says, nothing from the state, Your Honor. Mr. Steele, you don't have to if you don't want to. That's okay. Attorney Steele says, I want to. Judge Glanville, all right, go ahead. Attorney Steele, I don't think what's going on. Last I heard, you said there would be a hearing this morning with his lawyer. I don't know what's going on. I think I read that wrong. I don't know what's going on. Last I heard, you said there would be a hearing this morning with his lawyer, and we have been in the dark since. Glanville, okay, Mr. Copeland had the opportunity to speak with his lawyer, Ms. Bumpus. And it is my understanding he's going to testify. That is the latest I can give you, okay? So we're going to bring Mr. Copeland out and see what happens. So great summary by Glanville of what happened in that 3 hours. Oh yeah, he talked to his lawyer, that was it. After the lunch break, Attorney Steele made a motion citing his constitutional obligations under 6th and 14th Amendments to the United States Constitution and the corresponding sections of the Georgia Constitution, requiring Steele to make a full and complete statement to the court. The jury was not present. While Attorney Steele was disclosing what he learned about the ex parte hearing that took place that morning, Judge Glanville interrupted and said, how did you find out about any of that? Attorney Steele informed Judge Glanville that he was not going to answer the question, citing attorney-client privilege and attorney work product privilege under Rule 16 of Georgia Rules of Professional Conduct. Attorney Steele, you should have told me. What I want to know is why I wasn't there. Judge Glanville was personally offended by this. When Judge Glanville told Attorney Steele he had 5 minutes to give him an answer, Attorney Steele responded that he did not need 5 minutes and he wanted to continue. Judge Glanville did not allow Attorney Steele to continue and left the bench while Attorney Steele was doing his best to make a record. Judge Glanville later acknowledged that Attorney Steele had a right to make a motion after learning about the ex parte hearing, but claimed that Attorney Steele put himself in a particular position he's in regarding the alleged contempt. In addition to preventing Attorney Steele from making a full and complete record, Judge Glanville did not allow Attorney Steele to properly respond to the allegations of contempt. Judge Glanville told Attorney Steele, I don't want to know about your problems at this point in time. Judge Glanville was only concerned with how Attorney Steele learned about the ex parte hearing. Not, and this is quotes, not the substance of information Mr. Steele received or whether the ex parte conversation was proper. When Attorney Steele asked Judge Glanville why they could not discuss the substance without him having to provide his source, Judge Glanville responded, because you got some information that you shouldn't have gotten. Is anyone else, even though like we've gone through this, we've seen it, we've watched it, is anybody else like feeling like they're taken back to the moment and like, I don't know, getting irritated about it all over again? Let me keep going. Judge Glanville accused Attorney Steele of hiding behind Rule 16. When Attorney Steele cited comment 5 of Rule 16, Judge Glanville responded, "You can't violate something and then use the privilege." Judge Glanville oddly explained that the privilege in 16 would occur if you were in the right place, right time to begin with. You weren't. Yeah, so put him in a catch-22. Judge Glanville claimed that somehow Attorney Steele had surreptitiously gotten information in regard to the court's private ex parte conversation with a party. Judge Glanville accused Attorney Steele of eavesdropping to get information that was not meant for him to hear at that particular point in time. Judge Glanville accused Attorney Steele of contorting and perverting the process by getting information they shouldn't have had, and then saying the court did something wrong and that we should be entitled to have the transcript. Judge Glanville accused Attorney Steele of getting the information allegedly from an improper methodology, from one of two ways. He either eavesdropped, or somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible. I think that he had a conversation with somebody and he got some information that he shouldn't have gotten to begin with. Now, one other thing I'm noticing as we're reading this, are you guys noticing something repeated very often that we don't see in, when the other judges or the state talks about this issue? What are we seeing repeated over and over again? What phrase? What are we seeing the difference here? And yeah, you guys are saying we've got some feeling like it's happening all over again, feeling the same way. But we've got a phrase that these attorneys from Gactyl have no shame in using as much as they can. Ex parte, ex parte, ex parte, ex parte. We're not calling it an in-chambers meeting. So we'll continue here. So Judge Glanville accused Attorney Steele of putting the court at a disadvantage because I didn't invite you into that particular proceeding and I don't think you had the right to be there. Judge Glanville accused Attorney Steele of, quote, running a very thin professional responsibility line when Attorney Steele requested a hearing with all witnesses who were present during the ex parte communications. Judge Glanville continued, I don't think that you have cover at this point in time. I think that you have blown your coverage at this point because I do think that somebody told you some things that violate privilege. Judge Glanville alleged that Attorney Steele and other lawyers for the defendants got the information in a way that was not lawful to begin with. A prosecutor acknowledged that she did not know if the information was leaked to Attorney Steele's client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. I love reading this because it really hones down that the state, yeah, they're giving two possibilities, but both of those possibilities operate on the premise that it was a leak. And a leak implies what? That it's something that shouldn't have happened, shouldn't have been disclosed. And what's the ultimate problem here if we have exculpatory information going down at this in-chambers ex parte meeting? Exculpatory information should be closed, whether or not they held that meeting with or without defense present. But the two options we're getting from the prosecutor, who the court is backing up, it was either leaked or it was leaked. And the judge is saying you had no right to come across that information. So you must have been eavesdropping or got it surreptitiously some other way. It's great reading this. After holding Attorney Steele in contempt that afternoon, Judge Glanville sought to go forward with trial without Attorney Steele present. Judge Glanville accused Steele's co-counsel, Attorney Keith Adams, of extorting the court by refusing to go forward without Attorney Steele. An appellate court will review my decision for abuse of discretion. Well, here we are. According to Judge Glanville, Mr. Steele put himself in this particular position by refusing to disclose his source. Judge Glanville eventually allowed Attorney Steele to continue representing Mr. Williams at trial after the state requested that he do so. Judge Glanville told Attorney Steele that he would be taken into custody whenever they finished court that afternoon if he did not tell him his source. Judge Glanville alleged that Attorney Steele interfered with his ability to administer justice because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people. Judge Glanville's order finding Attorney Steele in contempt is devoid of facts showing that Attorney Steele posed an actual or imminent threat to the administration of justice. The order also failed to identify facts showing that Attorney Steele knew or should have known his refusal to answer the judge's questions about his source exceeded the bounds of permissible advocacy. So, even if the Georgia Supreme Court doesn't care about any of this, the context, the backing context, which I think was laid out great, the actual contempt order was deficient on the elements needed. So this paragraph is a short, concise, kind of separate issue that tacks onto this. Judge Glanville denied Attorney Steele a contested criminal contempt hearing before an impartial judge. When Attorney Ashley Merchant, counsel for Attorney Steele, asked Judge Glanville to recuse himself from the contempt proceedings because he was a witness, Judge Glanville responded, "I'll let an appellate court decide that." Attorney Steele was singled out as the only attorney held in direct summary criminal contempt or questioned about the source of information regarding the ex parte hearing, despite other defense counsel having the same information. Judge Glanville acknowledged he was not asking other defense counsel about the source. "Well, I asked him, so I didn't ask you." Judge Glanville sentenced Attorney Steele to the maximum jail sentence and denied Attorney Steele a supersedious bond without good cause, which we know the Supreme Court ended up granting. So this is an interesting paragraph here too, because, you know, it makes sense to me once it's laid out, but I just didn't really give consideration to, you know, it's also an additional issue if you're not holding other criminal defense attorneys for coming upon the same information. And then you explicitly state, well, I asked them, so I didn't ask you, as your reason for focusing on one only. So great, great stuff. Judge Glanville decided sua sponte, so that means on their own, without a prompting from either party, to seal the transcript and would not release it to the defendants or counsel for Attorney Steele. When Attorney Merchant asked for a copy of the transcript because it is germane to the contempt, Judge Glanville replied, "It's an ex parte matter, so you're not going to get it unless the appellate court wants to see if it's accepted. But I'm not going to give it to you at this point in time." Earlier that day, Glanville had stated, and we caught this, you guys, the chat was calling this out in real time. After Ashley Merchant said that in court and got denied by Judge Glanville, everyone was like, wait, he said earlier, we record these conversations so they can be reviewed later. If and when the case gets reviewed, an appellate court will make those decisions. When the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me. Imagine reading this as one of the Supreme Court judges presiding over this. Isn't this just kind of like poking the bear? Okay, sure, we'll tell you. It is recorded and taken down, so if it needs to be reviewed later, it gets reviewed. Judge Glanville said he was not going to order the transcript as of yet, because if the case should be reviewed, the appellate court would have that particular ability to do that. Judge Glanville reversed his position and subsequently entered an order on July 1st, 2024, regarding his decision to release the entirety of the transcript of the June 10th, 2024 ex parte conversation. The transcript of the June 10th, 2024 ex parte hearing revealed that Judge Glanville told Copeland he, the court, wanted to hear Copeland's testimony. Although the state initially requested the ex parte hearing, Judge Glanville implied it was the court when Copeland was brought into chambers. Look at the emphasis. If you guys aren't on the screen, I'm going to try to read it. Judge Glanville, so the first word of Judge Glanville speaking here from the transcript that's being cited is I. Me, I. It's bolded and it's underlined. Judge Glanville says, I just wanted to bring you, Copeland, over and let you talk with your attorneys and see if there is anything that you need to ask of your counsel or Miss Prosecutor or the state or the court before we bring you out this morning, because it is, we would like to hear your testimony, and we is bolded and underlined. Copeland made numerous exculpatory statements to the judge, prosecutors, his counsel, and other court personnel. Quote, I did these crimes, I'm telling you that. Quote, I have never been truthful a day in my life until I just made this statement right now. Quote, so I didn't tell you I lied on them to get myself out of the situation? The prosecutor suggested how Copeland could testify about matters previously discussed. A prosecutor told Judge Glanville he, quote, might want to close his ears before informing Copeland he would not be prosecuted, quote, if he confessed to a murder on the stand. And that's all in quotes. If the state did not have independent evidence. At one point, Copeland inquired about the statute of limitations for murder, an offense alleged in the underlying indictment. Copeland's involvement in the murder of Donovan Thomas is a substantive fact in issue. Substantive, U.S. pronunciation. Copeland was advised in the ex parte hearing that he would not be prosecuted for perjury even if they knew he was lying. Quote, "If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that." The prosecutor gave Copeland legal advice on various issues, including the statute of limitations for crimes she and Copeland discussed that she independently researched. The prosecutor told Copeland he, quote, "had spent enough time in prison for YSL." Whether Copeland was incarcerated, quote, "for YSL," was a substantive fact in issue. The prosecutor mentioned prior inducements for Copeland's testimony in the form of living arrangements. Now, this is a footnote here that says Copeland was not concerned about his safety. So remember, that was what they tried to hint, that it could have been for safety concerns. Copeland was advised that he could not be prosecuted for anything in federal court or other jurisdictions. The immunity order expressly states that Copeland, quote, shall not be required to produce evidence that can be used in any other court of this state, the United States, or any other state. Holy moly, do I love reading that. There we go. This is Gactyl. This is multiple defense attorneys saying, the advice he was given on this immunity order. This is the quote. This is the quote. Within the immunity order itself, contradicting what Hilton told Copeland in this ex parte meeting. Hallelujah. Doesn't this feel really validating? Doesn't it feel good to see some emphasis, because we've read this line on this stream, we've looked at it on X, we've talked about this, so many of us. But now we're seeing a bunch of attorneys like, hello, look at this quote. It says shall not. This is very, very validating. Thus, Copeland does not appear to have immunity in any court other than Fulton County Superior Court, pursuant to Judge Glanville's June 7th immunity order. Isn't that, look at that, the validation. There we go. There we go. Whew. And while I'm taking a breath here, shout out to, we had Amy E, the beautiful Amy E says, directed over here after Classy's live. Thanks so much for coming over, Classy. Y'all hit the like button for Kat. Happy Friday. And I'm sure, you know, my mods are always on top of things. But here's a quick link drop just in case. And always love hanging out. You know, I love to tune into Classy Beats, but I also love hanging out with Amy over in the chat over there. So make sure you go over there and hit the like button. It'll help you get your YSL content fix and then some. Thank you so much for showing the love and support, Amy and Classy. And Rice Street dropping 5 memberships. I see you guys. I was like, make Rice Street great again. What's going on in the chat? Rice Street's trying to bring in new members. Shout out to Rice Street, our resident Rice Street in the chat. Thank you so much. Mark in Texas says, big fat 0 on the credibility scale, talking about the Mungtuk please. I also think Love's threat to revoke went over like a lead balloon. Yeah, just like... I would love to see Love make an argument to rebuke yet somebody else at some point in the future. She's bound to keep trying. R for rebuke. Mark in Texas also says, S Satchel, my X handle. Oh yeah, we're gonna get some debating. Tom Telly Rand would have fun with discussions like this. And you know what? Mark in Texas, you have great insights. Let me drop your X. X.com. Because I love seeing you pop up on my feed. And I feel like there are some people in this chat that use X that are kind of on their own island on X. And if you guys are looking for more YSL people, you can share your handles in the chat. This is Mark in Texas because I have it handy. But super informative. I loved your insights on, you know, the plea agreements in general. And I would love to see some back and forth there. Bilal sends the dollar. Thank you so much, Bilal Brown. Happy Friday to you. Okay. And Steven Satchel, I'm not on any social media, sir. Love you guys both. Thank you for both bringing insights. And yeah, let's reread this last part. Let's reread this paragraph, you guys. Thank you, NJB. Let's look over here. Let's read this paragraph. I'm gonna pull this off the screen so you can see the bottom. Well, I guess since it's another page, we'll do that. And this is a huge paragraph. So we go through all of these quotes about the things Copeland was saying. You know, the prosecutors say, you know, he won't be prosecuted if he confessed to the murder on the stand. The judge should probably close the ears. Then Copeland inquires about the statute of limitations for murder, an offense alleged in the underlying indictment. Copeland's involvement in the murder of Donovan Thomas is a substantive fact and issue. Now, this is what we're going to really see argued, is the advisement. So we know that there's one issue of the exculpatory evidence not being disclosed by the state, and then the judge acting like the defense didn't have a right to it. But what about this legal advice given to Copeland? Copeland was advised in the ex parte hearing that he would not be prosecuted for perjury even if they knew he was lying. Quote, if I know right now he's lying, I know he's lying, I'm not going to charge you because I don't know your reason for doing that. End quote. The prosecutor gave Copeland legal advice on various issues, including the statute of limitations for crimes she and Copeland discussed and that she independently researched. This is a very slick way of saying she independently researched and got it wrong. The prosecutor told Copeland that he had spent enough time in prison for YSL. Whether Copeland was incarcerated, quote, for YSL was a substantive fact and issue. Now, here's the beautiful part. The prosecutor mentioned prior inducements for Copeland's testimony in the form of living arrangements. Footnote says Copeland was not concerned for his safety. Copeland was advised that he could not be prosecuted for anything in federal court or other jurisdictions. The implication that between these lines here is they're doing this all just to induce his testimony. What does it take to induce testimony from Copeland? The promise that he would not go to jail, the promise that he would not have to do time. That's all he cared about. He wanted his freedom. The immunity order expressly states that Copeland, quote, shall not be required to produce evidence that can be used in any other court of the state, the United States, or any other state. Thus, Copeland does not appear to have immunity in any court other than Fulton County Superior Court, pursuant to Judge Glanville's June 7th, 2024 immunity order. So that's a huge paragraph. That is a huge, huge paragraph there. And I know we've all been like racking our brains like this immunity order doesn't seem gravy. How did they double down in court to say he's protected federally? And we've got highly credentialed. We have Gactel saying he's not actually protected in any other court except for Fulton County Superior Court under this order. So it goes on to say, another prosecutor disclosed attorney-client privilege information between Copeland and his counsel that the state, quote, overheard. They are going to hammer you. So the state is violating attorney-client privilege by disclosing onto the record what Melnick said. They said they overheard it. Quote, overheard. The prosecutor asserted in open court that the state was concerned, quote, information disclosed in an ex parte setting got relayed to the parties who were not privy to that. Bold, the whole purpose of the ex parte request was so that did not happen. There you go. Judge Glanville said the hearing was ex parte because that is what the state asked me to do. In his July 1st, they are hammering this down so beautifully. Like point for point. This is such a clear argument. I'm loving it. In his July 1st, 2024 order, Judge Glanville found that he complied with CJCR 29 by releasing the entirety of the transcript of the June 10th, 2024 ex parte conversation and providing the parties an opportunity to respond. Judge Glanville clarified in footnote 5 that, quote, the opportunity for the parties to respond will be reserved for later, subject to whether another judge finds the recusals warranted here. According to Judge Glanville, the only thing discussed between the state, counsel for Mr. Copeland, and this court was the understanding of Copeland's immunity agreement, which we know the result was still not him having clear understanding. Judge Glanville found that his June 10th, 2024 ex parte communications with the state were proper, pursuant to Rule 2.9, where no party gained any tactical advantage and where the transcript of the proceeding will be released. Judge Glanville's... Did I miss a footnote? Okay, no, I didn't. Judge Glanville's July 1st, 2024 order does not include any reference to the additional ex parte communications between prosecutors and Judge Glanville that occurred shortly after court ended Friday, June 7th, 2024, the day Copeland was taken into custody for invoking his Fifth Amendment privileges. We have 2 footnotes in that sentence. So in the first half, we have Exhibit B citing, this is where we get the June 7th transcript brought in through the appendix, the exhibits here. They're citing Diamante Kendrick's motion for mistrial. And then footnote 3 says Judge Glanville refused to give Attorney Steele a copy of Copeland's immunity order when he asked for it on Friday, June 7th, 2024. Not yet, sir. It doesn't apply to you yet, Mr. Steele. The immunity order still had not been provided to Attorney Steele or any defendants when court resumed on Monday, June 10th, 2024. And I don't really, maybe they'll keep going. Maybe they'll get to this in a future page, but remember Shart, like, sometime later was still asking, we've still never seen the immunity order. So the substance of the Friday, June 7th, 2024 ex parte hearing between the state and Judge Glanville was revealed to Attorney Steele and the defendants after Judge Glanville was recused from the case. During the Friday, June 7th, 2024 ex parte communication, so the Friday, a prosecutor advised Judge Glanville that the state would be looking for a remedy for, quote, Melnick's insertion of himself over the weekend and that she wanted to inform Judge Glanville so that you are not caught off guard Monday morning or Saturday night or Saturday afternoon. We find it and send it to you. Exhibit B at 14. At the end of the meeting, Judge Glanville told the prosecutors, quote, if you find anything, we'll see where Monday leads us. And that's from Exhibit B. Melnick's interest was a concern that the prosecutor raised at the beginning of the Monday 10th, 2024 ex parte hearing, in line with the concern that she expressed on the record on Friday. According to Judge Glanville's July 1st, 2024 order, on the morning of June 10th, 2024, Judge Glanville was informed by his litigation manager that attorneys for the state requested an ex parte conversation with the court. The subject matter of the ex parte conversation is not told to the court in advance. And now argument and citation authority. So this might be some new stuff for us to look at, and this is where they try to argue, Supreme Court, this is the case law. This is how you're supposed to go with this. So hear us out. Vigorous advocacy is essential not only to the preservation of individual rights, but also to the integrity of the judicial system, whose truth-seeking process is sought to be protected through the exercise of the contempt power. Courts must be judicious in their approach to adjudicating contempt. In Reed Jefferson, 283, Georgia, 216, 221 from 2008, quote, contempt is a drastic remedy, which ought not to deprive one of his liberty unless it rests upon a firm and proper basis. In Ray Johnson, this is the 2022 from Georgia Appeals Court, and it cited Ford v. Ford, a 1998 case. Before holding an attorney in contempt for statements made during courtroom proceedings, the court must find, beyond a reasonable doubt, that 1, the attorney's statement and conduct either actually interfered with or posed an imminent threat of interfering with the administration of justice, and 2, the attorney knew or should have known that their statements and conduct, quote, exceeded the outermost bounds of permissible advocacy. So, beyond a reasonable doubt, and the behavior itself also needs to be the worst of the worst. In Ray Jefferson, at all times, that's from In Ray Jefferson. At all times relevant, Attorney Steele was facilitating the search for truth, not hindering it. And that's cited back to same case. A beautiful sentence here. At all times relevant, Attorney Steele was facilitating the search for truth, not hindering it. Justice must satisfy the appearance of justice. That's Offit versus United States. That's a 1954 case. There are many instances where the trial court's actions do not reflect an administration of justice. This includes the court repeatedly questioning a single defense attorney about the source of privileged information the judge himself was required to disclose. Powerful sentence. And we're seeing some of the stuff from earlier tie back in here. It was improper and not an administration of justice for Judge Glanville to hold Attorney Steele in criminal contempt with a maximum jail sentence solely because Attorney Steele refused to answer the judge's question when doing so would have required him to violate attorney-client privilege. It was improper and not an administration of justice for Judge Glanville to engage in numerous ex parte communications with prosecutors and a sworn witness, and then withhold the existence and substance of those communications from the defendants, while simultaneously depriving them of an opportunity to be heard. It was improper and not an administration of justice for Judge Glanville to interrupt Attorney Steele's repeated attempts to make a record about the court's ex parte communications with a sworn witness and prosecutors. Quote, to sanction such a course of procedure would give it encouragement. And that's citing the Offutt United States case. If Judge Glanville's concerns about the administration of justice were relevant to the, quote, sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people, there were other correctives sufficient to address those concerns before Judge Glanville held Attorney Steele in criminal contempt. In Ray Jefferson, 283, Georgia at 221, so they're citing one of the Jefferson cases again. For example, Judge Glanville could have ordered, and later did, all parties who were in attendance during the ex parte hearing to appear before the court to determine the source. Judge Glanville, that was the show cause. Judge Glanville could have ordered all attorneys for defendants to disclose the source of this information. Because Judge Glanville did not understand the nature of the attorney-client privilege asserted by Attorney Steele, he could have gone in chambers and asked. Beautiful, I'm so glad they included this. Because Judge Glanville did not understand the nature of the attorney-client privilege asserted by Attorney Steele, he should have conducted an in-camera review rather than repeatedly asking Steele to reveal his source in open court. Instead of pursuing these reasonable alternatives, Judge Glanville singled out Attorney Steele and held him in direct summary criminal contempt, with the maximum jail sentence simply because Attorney Steele was vigorously advocating on behalf of his client and refused to violate attorney-client privilege by disclosing his source. So see in Ray Lightfoot, that's a Georgia appeals court from 2021, reversing contempt where public defender refused to disclose source because, quote, other actions might have achieved the same result without holding Lightfoot in contempt. Great, that sounds right on point. That sounds right on point, and it's from 2021 with the Georgia appeals court, a lower court than the Supreme Court, reversing contempt against a public defender. Because there could have been other ways. They could have had an in-camera, they could have gone into chambers and said, look, this is why I think this information is privileged. Let me talk to you in here instead of an open court. They could have asked the other attorneys. This is so good to read. I love reading this stuff. Holy moly. It is not criminal contempt for a defense attorney to refuse to violate attorney-client privilege, nor is it criminal contempt when a judge provokes the extraordinary circumstances surrounding the alleged contempt and then refuses to recuse himself after becoming personally embroiled with the attorney. The trial continued after Judge Glanville permitted Attorney Steele to return to the courtroom, even though Attorney Steele did not reveal his source. This indubitably demonstrates that Attorney Steele did not obstruct or hinder the administration of justice. Another good call out. That's something I wouldn't have thought to argue, but that's a good argument. Like, obviously things could continue, so the basis for holding someone in contempt didn't exist by their own decision. And now we're getting to breaking down these arguments. So A, Attorney Steele was vigorously advocating on behalf of his client, and his refusal to violate attorney-client privilege is not criminal contempt. As counsel for Mr. Williams, Attorney Steele had a right to make a record of what he learned about the ex parte communications. An attorney may not be held in contempt of court merely for presenting in good faith a motion in which he has a right to make, nor may an attorney be held in contempt merely because, having filed such a motion, he fails to prevail on it. In Ray McLarty, 152 Georgia Appeals, 399 400 1979, quote, it is essential to a fair administration of justice that lawyers be able to make honest, good faith efforts to present their clients' cases. In Ray McConnell, which is a 1962 U.S. case, where the judge is arbitrary or affords counsel inadequate opportunity to argue his position, counsel must be given substantial leeway in pressing his contention. In Ray Dellinger, another federal case in the Seventh Circuit, doubt should be resolved in favor of vigorous advocacy, and any balancing test for determining whether advocacy interferes sufficiently with justice to make it punishable must also consider the positive value of the advocacy to the very interests sought to be protected by the contempt power. And then we're going back to In re Jefferson, the Georgia case. So a ton of case law there, kind of spelling it out like, yeah, you shouldn't have been holding Steele in contempt. He was just advocating for his client. So what's up? This court held that one of the factors courts should consider in determining whether to hold an attorney in contempt is, quote, the significance of the particular issue in question to the case as a whole, and the relative gravity of the case. That's also from Jefferson. The information attorney Steele was attempting to put on the record regarding what he learned about the morning's ex parte hearing was of great significance to the RICO case as a whole. This is particularly true in hindsight, considering the exculpatory statements made by Copeland that were not disclosed to the defendants and attorney Steele's belief that the ex parte hearing involved coercion and witness intimidation. The positive value in attorney Steele's vigorous advocacy far exceeds any privacy interests surrounding Judge Glanville's ability to conduct ex parte hearings with prosecutors and a sworn witness. The gravity of the RICO case involving many serious charges, including murder, is clear. Like the prosecutor who was erroneously held in contempt when he refused to go forward with trial, Attorney Steele was professional and respectful of the bench in carrying out his obligations and responsibilities as counsel for Mr. Williams. So we're going to In re Berger, a Georgia appeals case from 2003. Attorney Steele simply refused to violate his duty of confidentiality to Mr. Williams to protect Mr. Williams and the sanctity of his attorney-client relationship. Attorney Steele repeatedly explained to Judge Glanville why he could not reveal the information. Conversely, Attorney Steele was threatened with confinement early in the proceedings without any showing of contempt. In re Brookins, that's a Georgia appeals, 1980, there is nothing indicating that Attorney Steele's refusal to violate his ethical obligations by disclosing privileged information, his source, was such an open, serious threat to orderly procedure that instant and summary punishment, as distinguished from due and deliberate procedures, was necessary. And that's Harris v. United States, 1965. Tons of case law. Attorney Steele's refusal, and remember, if we get a response to this, the state already said that they don't want a part in responding to this. They don't feel like they're a party. I don't know how they can kind of argue that when, with Fani Willis helping to draft the immunity order, that seems intimately tied in with June 7th and June 10th. But maybe the Supreme Court will agree that the state itself shouldn't be a party. This is really just Glanville. Whoever has to respond to this, whoever the Supreme Court deems is the party that needs to respond, needs to address each of these. And I'm waiting to see the response. Will we even get case law arguing a counterpoint for half this stuff? Will we see them try to reinterpret the purpose of this ex parte meeting, the two ex parte meetings? So think about that as we get through the rest of these arguments, what their response could or might be. Attorney Steele's refusal to violate attorney-client privilege without his client's permission is not criminal contempt. We're starting with a common sense, a black letter of the law type argument. Like, duh, right? You guys in the chat, put a 1 in the chat if this is common sense to you. If you understand this as a layperson, that Attorney Steele's refusal to violate attorney-client privilege without his client's permission is not criminal contempt. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. Comment 5, Rule 1.6, quote, that a lawyer maintain confidentiality of information relating to the representation is a fundamental principle in the client-lawyer relationship. And look at you guys. Look at you guys. Look at all the lay people in the chat understanding this common sense thing that Judge Glanville tried to push back on. Shout out to us lay people. There we go. We got an Uno. Shout out to you guys in the chat. Comment 5, Rule 1.6, that a lawyer maintain confidentiality of information relating to the representation is a fundamental principle in the client-lawyer relationship. The attorney-client privilege is the oldest of the privileges for confidential communications known to common law, and has long been recognized in Georgia. The privilege belongs to the client, not the attorney. So even if Steele wanted to violate it, it's not his duty to say, all right, judge, just because you asked me to, I'm going to make the decision because I can make that decision to disclose something to you. you know, Judge Glanville never looked over at Jeffrey Williams and said, hey, do you want to give permission to disclose this? Do you want to disclose it? He only asked Steele. The privilege belongs to the client. It is essential to constitute a contempt that the thing ordered to be done be within the power of the person against whom the order is directed. Great argument. This inability to comply would have been ground of defense before the judgment of contempt. Just as the attorney in Ray Brookins was unable to proceed to trial, so too was attorney Steele legally and ethically unable to answer Judge Glanville's question. Doing so would have required attorney Steele to reveal privileged information that he, attorney Brian Steele, was not authorized to share, thereby destroying the duty of confidentiality he owes to Mr. Williams and causing irreparable harm to the attorney-client relationship. Additionally, if attorney Steele answered Judge Glanville's question and revealed his source, the applicability of the attorney-client privilege to that information would have been rendered moot. Judge Glanville's decision to hold attorney Steele in criminal contempt for refusing to violate attorney-client privilege is analogous to the judge in Maness v. Myers, that's a 1975 U.S. case, holding the attorney in contempt for advising his client, in good faith, to refuse to produce court-ordered materials on the ground that the materials may tend to incriminate the client in a further proceeding. If performance of a lawyer's duty to advise a client that a privilege is available exposes a lawyer to the threat of contempt for giving honest advice, it is hardly debatable that some advocates may lose their zeal for forthrightness and independence. An advocate is not subject to the penalty of contempt for advising his client, in good faith, to assert the Fifth Amendment privilege against self-incrimination in any proceeding embracing the power to compel testimony. To hold otherwise would deny the constitutional privilege against self-incrimination the means of its own implementation. And that's from the Maness case. Attorney Steele asserted attorney-client privilege as the basis for refusing to answer Judge Glanville's question in good faith, and he was in no way contumacious in doing so. Had attorney Steele complied and answered Judge Glanville's question, there would have been irreparable injury, because appellate courts cannot always unring the bell once the information has been released. Subsequent appellate vindication does not necessarily have its ordinary consequence of totally repairing the error. That's Maness. This court should extend the sound reasoning in Maness to the facts currently before the court and find that an attorney cannot be held in contempt for asserting attorney-client privilege on behalf of a client or advising their client to do the same. Now, that's the end of argument A, so one grounds. And with the Supreme Court, they can rule in part, they can disagree with all of it, they can agree with all of it, but we should see the Supreme Court of Georgia acknowledge each of the arguments. And I think argument A is great. I loved reading that. So we're now going to look at B, which is Judge Glanville should have recused himself from the contempt proceedings because he provoked the extraordinary circumstances giving rise to the alleged contempt and became personally embroiled with attorney Steele. Appellant Steele's conduct cannot fairly be considered apart from that of the trial judge, and that's from Offit, a U.S. case, an important factor courts must consider when determining whether to hold an attorney in contempt is the extent, if any, to which the trial court provoked the offending statements with its own improper statements. So in Ray Jefferson, lots of Jefferson citations here, which also cited Little, a U.S. case. Trial judges must be on guard against confusing offenses to their sensibilities with obstruction to the administration of justice. The contempt power entrusted to a judge is wholly unrelated to his personal sensibilities, be they tender or rugged. Courts should limit their orders to the least possible exercise of power required. Let's read that again. Courts should limit their orders to the least possible exercise of power required. In layman's terms, it says no power tripping, and should not impose punishment without first affording minimum due process to the accused. But what did we get here with Glanville? We got max sentencing. Deal with it later. You can look at the transcript later. We'll just, for now, you'll get the max. And now we're getting to we get CJ CR 29 and US CR 21. So this is more authority, not coming from case law, but coming from different rules. Judge Glanville's failure to comply with Code of Judicial Conduct Rule 2.9, provoke the extraordinary circumstances giving rise to Attorney Steele's alleged contempt. I think Rule 2.9 is the one about ex parte meetings and how the court isn't supposed to look or seek information that's off the record. Let me just double check that. Yeah, the ex parte rule. So let me just pull this up quick so you can see. We've looked at this a lot. I think that's why Rule 2.9, I remember it now. You know, the judge shall not permit or consider ex parte communications, blah, 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 except for these 4 exceptions or 5 exceptions. I'll paste this rule, but we know the basics of it. And that is a long Google link. Let me make sure I get the correct link for you guys. So there you go. If you want to take a deeper look at Rule 2.9, we've gone over it a lot. Where was my share? Was it this one? There we go. So talking about Rule 2.9 here. So Judge Glanville's failure to comply with the code, the established code, provoked the extraordinary circumstances giving rise to Attorney Steele's alleged contempt. They also give a footnote here citing to USCR 4.1, which says that ex parte communications are presumed to have been in error. Copeland's testimony was an impending matter that was extremely important and possibly pivotal. Possibly pivotal. Yeah. I mean, look how many people were just stunned and astonished by what came out through Kenneth Copeland's testimony and or those videos. Possibly pivotal to the ongoing RICO trial. Judge Glanville specifically advised all parties, including Attorney Steele, in open court that he would address Copeland's testimony when court resumed Monday morning. There was no legitimate reason for the state to request ex parte communications with Judge Glanville, Copeland, a sworn witness, and his counsel, especially when they knew his counsel was going out of town. Well, that's my addition there. Judge Glanville should have immediately stopped the state's attempt to engage the court in these improper communications. So it's Judge Glanville's fault. He started the problem. He knew he shouldn't have done this, and it's not Brian Steele's fault that he responded to this thing that never should have happened in the first place. Judge Glanville's suggestion to Copeland that he was the one requesting the ex parte communications, the I, we saw it underlined and bolded, I am bringing us here. Judge Glanville's suggestion to Copeland that he was the one requesting the ex parte communications was also a violation of CGR CR 2.9 because judges are not permitted to participate in or initiate such communications, even if done with good intentions or no intention of favoring one party over another. The footnote here says, see this inquiry concerning Anderson and inquiry concerning Peterson. So they're citing these, this is Judge Peterson, Christina Peterson. So they are citing the, what's the commission called? The Judicial Qualifications Commission. So there was an inquiry made, and the Judicial Qualifications Commission put a report together and brought that report to the Georgia Supreme Court. I don't know the backstory on Anderson, but I'm assuming it's the same procedure. So the Judicial Qualifications Commission issues their report, Georgia Supreme Court reviews it. They agreed with 4 of the issues raised and ruled that it was worth removing her from the bench. And one of those issues was about a contempt proceeding that involved scheduling that the court clerk participated in, not even the judge directly. A second issue involved the Judge Peterson holding a party in contempt for the maximum incarceration amount when the maximum wasn't warranted. And we looked at that on another stream. A lot of people have talked about that, but they are citing this. This just happened like 2 months ago, maybe at this point. And they're putting it in a footnote here. Very interesting to see. Now let me go back up to this footnote. I don't remember where I was. Where was 6? Okay. So Judge Glanville did not present an appearance of a fair and impartial judge when he failed to comply with CJCR 2.9 and told Copeland he had an interest in hearing Copeland's testimony. Even when Attorney Steele inquired about the case of the delay, the cause of the delay, before Copeland took the stand, Judge Glanville withheld information about the ex parte hearing and suggested that Copeland's counsel was the only person Copeland spoke to before he decided to testify. It was Judge Glanville's duty to disclose to Attorney Steele and counsel for the other defendants the existence and substance of the ex parte communications that occurred in chambers with Copeland that morning and all other times, and to afford the defense an opportunity to respond. The right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. Judge Glanville also did not present the appearance of a fair and impartial judge when he failed to abide by the well-established procedures for sealing public records set forth under Uniform Superior Court Rule 21. USCR 21 creates a presumption that all court records are to be open to ensure the public's continued enjoyment of its traditional right to access judicial records. And this is the Savannah School of Art and Design versus School of Visual Arts, a 1999 case. USCR 21 through 21.6 establish specific procedures that courts must follow before shielding such records from public view. And that's Altman versus Altman 2017. As the party seeking to seal the June 10, 2024 ex parte transcript, Judge Glanville failed to meet his burden of demonstrating that the harm to the privacy right he was asserting clearly outweighed the public's substantial interest in access to the records. This was, so this is an Atlanta Journal-Constitution case. Shout out to AJC from 1999. So this seems like a case where AJC was fighting for public access to records. Shout out to AJC. Tons of coverage on all things Fulton County and this YSL case. Judge Glanville did not hold a hearing on his decision to seal the transcript, despite Attorney Steele and the defendant's numerous requests for a copy. USCR 21-1, Attorney Merchant, counsel for Attorney Steele, requested a copy of the transcript in open court because it is germane to the contempt. Judge Glanville denied this request. The requirement of a hearing held upon reasonable notice is indispensable to the integrity of the process mandated for limiting access to the court records. So that's that AJC case. So shout out to, back then, that's decades ago already, 1999, but AJC, I talk about Joseph Papp a lot. He's a writer, he's a contributor to AJC, bringing tons and tons of transparency into this case and tons of other cases. They've been doing it for decades. Judge Glanville did not specify, quote, the nature and duration of the limitation and the reason for limitation. USCR 21.1, nor did he make a finding that the harm otherwise resulting to the privacy of a person in interest clearly outweighs the public interest, and that's USCR 21.2. It is insufficient for the trial court to forgo making findings of fact and simply state that the public's interest in access to court records is clearly outweighed by potential harm to the party's privacy. And that's again from the AJC case. No compelling circumstances were present, and Judge Glanville did not file an ex parte order granting his purported, quote, motion for temporary limitation of access that required a supporting affidavit. Ooh, they got the whole procedure womped down here. So USCR 21.3, justice faces its gravest threat when courts dispense it secretly. Our system abhors star chamber proceedings with good reason. Like a candle, court records hidden under a bushel make scant contribution to their purpose. And that's from a different Atlanta Journal versus Long. That is from 1988. And we get bolded quote, publicity is the very soul of justice. So footnote 7 here is citing, and this is where we get some of that kind of expert analysis, legal analysis from David Ardia in a writing called Court Transparency and the First Amendment, published in 2017. And this case illustrates the importance of the right to access court records that is indispensable to defendants and the public at large. Number 8 footnote says, including the transcript of the Friday ex parte communications between prosecutors and Glanville, that was not prepared or provided to Attorney Steele and the defendants until after Judge Glanville was recused. Because remember, Whitaker was like, oh, we found out about another transcript. Anything else we know about? Were there any other ex partes? So we get that long after Judge Glanville was recused. It was improper for the trial court to keep this material entirely off the record. So go back up here. It continues to read that suppose the proceedings to be completely secret, and the court, on the occasion, to consist of no more than a single judge, that judge will be at once indolent and arbitrary, how corrupt soever his inclination may be. It will find no check, at any rate, no tolerably efficient check, to oppose it. Without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. Recordation, appeal, whatever other institutions might present themselves in the character of checks, would be found to operate rather as cloaks than checks, as cloaks in reality, as checks only in appearance. And I love that we can tell that this case is, 1948 would probably be a close ballpark guess based on the verbiage here. So that's from In re Oliver from 1948. That's a U.S. case. But really it's saying, like, without the sunlight, how would we be able to keep checks in place? How do we check something if we don't know what's happening? By violating CJCR 29 and the procedures set forth under USCR 21, Judge Glanville provoked the extraordinary circumstances giving rise to Attorney Steele's alleged criminal contempt, rendering any finding of contempt moot. Now, the personal embroilment. It is expecting too much of any trial participant to silently suffer the abuse of the court. Such abuse should negate the wrong intent of counsel. We get a footnote here to another, expert legal analysis by Louis Ravison, Advocacy and Contempt Part 2, Charting the Boundaries of Contempt, Ensuring Adequate Breathing Room for Advocacy, and that's a publication from 1990. As in Offutt, Judge Glanville became personally embroiled with Attorney Steele. Judge Glanville did not question any of the other defense attorneys or hold them in contempt, even though they had the same information about the ex parte hearing as Attorney Steele. There was nothing Attorney Steele did to warrant Judge Glanville's personal embroilment with him. This one-sided personal embroilment requires Judge Glanville to recuse himself from the contempt proceedings. And now, also, just as a side note, what I think is important here, I remember one of the defense attorneys getting up saying, and quite frankly, we're still in the dark. But we do have at least one other motion. I think it was Doug Weinstein that filed it. So we have these affidavits, we have these motions. I believe it was Doug Weinstein. So at least there's proof that at least one other person, at least within a few days, before the recusal of Judge Glanville, had the same information. So they became aware of the same information. So I bet you will get a counter argument that, hey, one of them said, quite frankly, we're still in the dark. But it doesn't matter because they all learned of the information that Brian Steele had. So, but I'm expecting that to be one counter argument. But yeah, this one-sided personal embroilment required Judge Glanville to recuse himself from the contempt proceedings. The record discloses not a rare flare-up, not a show of evanescent irritation, a modicum of quick temper that must be allowed even judges. The record is persuasive that instead of representing the impersonal authority of law, the trial judge permitted himself to become personally embroiled with the petitioner. There was an intermittently continuous wrangle on an unedifying level between the two. For one reason or another, the judge failed to impose his moral authority upon the proceedings. His behavior precluded that atmosphere of austerity, which should especially dominate a criminal trial and which is indispensable for an appropriate sense of responsibility on the part of the court, counsel, and jury. Such an atmosphere will also make for dispatch insofar as in consonant with a fair trial. The manner in which this trial was conducted doubtless contributed to the wastefulness of 14 trial days. Oh my God, you can almost add a digit to that. The manner in which this trial was conducted doubtless contributed to the wastefulness of 14 trial days for a case of such limited scope as was the Peckham prosecution. Oh boy. I bet they loved including this. Oh, wasting time for 14 days? And that's from Offutt. Judge Glanville reacted to the conduct in such a manner as to have become involved in the controversy, thereby requiring the contempt hearing to be held before another judge. In Ray Hatfield, that's the Georgia Appeals case from 2008, Judge Glanville was personally offended when Attorney Steele stated on the record that he was aware of the improper ex parte hearing that Judge Glanville should have disclosed. Judge Glanville's personal embroilment with Attorney Steele is clear, given the numerous inflammatory, baseless allegations he made against Attorney Steele in open court without giving Attorney Steele an opportunity to respond. He repeatedly interrupted Attorney Steele's continued efforts to make a record. Yes, he did. In Ray Sprayberry, a Georgia appeals case, the transcript also shows that the trial court repeatedly interrupted Sprayberry as she attempted to explain herself. They even got the case law on the interruptions. Judge Glanville singled out Attorney Steele and did not ask anyone else to reveal the source. Judge Glanville was required to recuse himself from the contempt proceedings because he became personally embroiled with Attorney Steele and was the primary witness in the contempt proceedings. And remember, this was really the findings of Judge Krause. Like, Judge Krause didn't really call it embroilment, but, you know, the idea that the parties just inherently were in conflict now that they were taking this case up to fight the contempt. But in a way, this argument is saying that it was even worse. It was personal, it was embroilment before this contempt issue was filed as an appeal. One cannot be both the prosecuting witness and the judge in our judicial system. Here, the trial judge imposed upon Attorney Steele the sanction of jail time without having first afforded him meaningful opportunity to defend himself against the trial judge's conclusion that his conduct was contemptuous. The attorney was personally charged by the judge with unprofessional conduct, and no appeal could be taken from the judge's remarks. Can a judge make such a charge and deny the attorney the right to answer? Must the attorney stand silent and helpless in face of such a charge? Is it contempt of court for the lawyer to insist that he is entitled to answer the charge? A charge that an attorney is guilty of unprofessional conduct is a serious charge and is even more serious and damaging when made by a judge in open court. Fundamental fairness requires that the attorney be given reasonable opportunity to answer such a charge. A judge has no right to make such a charge and then deny the attorney the right to be heard, and it is not contempt of court for the attorney to insist on being heard. Of course, the attorney does not have unlimited time to be heard, and his answer must be in a respectful manner, but he does have the right to be heard and should not be penalized for attempting to exercise that right. And that's a new one. This is a DC case in Ray Absey. A hearing, and only a hearing, will elucidate all the facts and assure a fair administration of justice. Then, courts will not act on surmise or suspicion, but will come to the sentencing stage of the proceeding with insight and understanding. Make Glanville testify. The right to be heard in open court before one is condemned is too valuable to be whittled away under the guise of demoralization of the court's authority. That's from In re Oliver. Trial judges must disqualify themselves where their impartiality might reasonably be questioned. Attorney Steele had a right to be heard by an impartial judge on the alleged contempt, and Judge Glanville denied Attorney Steele that right by refusing to recuse himself from the contempt proceedings. Judge Glanville was a necessary witness, and he should have recused himself after becoming personally embroiled with Attorney Steele. Judge Glanville erroneously refused to recuse himself and deferred the issue to the appellate courts to decide whether he abused his discretion. Oh, this is great. Attorney Steele was engaged in the type of vigorous advocacy that this court and courts throughout the nation, including the United States Supreme Court, have encouraged. It was not criminal contempt. Well, that was a big scroll, my bad. It was not criminal contempt for Attorney Steele to refuse to violate attorney-client privilege by answering Judge Glanville's question regarding his source. It was not criminal contempt when the trial continued after Judge Glanville released Attorney Steele from the holding cell to return to court. Judge Glanville had alternative measures he could have pursued to obtain the information he sought, but he chose to target Attorney Steele instead. There was no criminal contempt because Judge Glanville provoked the extraordinary circumstances giving rise to Attorney Steele's alleged contempt, and he was required to recuse himself from the contempt proceedings after becoming personally embroiled with Attorney Steele. So, respectfully submitted on this 11th day of September 2024. It's within the word count limit. And again, shout out, we've got Hunter Rogers, Maisie Lynn Garreton, Jessica Jones, Greg Willis. And then all of the, everything that they've cited here, we've got the transcripts. Let me link this to you guys in case you want to read it on your own. Thank you again to Beck and Thugger Daily. So there is the brief. What do you guys think? What do you guys think? And I see, we have a troll in here somewhere. Shout out to the mods for holding it down while I got through that document. Thank you, thank you, thank you. I'm scrolling and I don't even know what we're trolling about. But shout out to the mods. Shout out to the mods. Oh boy. I will have to scroll through this when we end the stream, and I'll see what happened. And then shout out all the love in between this reading. You know, sorry, I like to keep it moving when we're reading things without interruptions. But again, thank you for the support in between. Shout out again to NJB for having us pause and read that part again. That was a few parts in here were like, nice, just nice. And Steven Satchel here had said, oh, to Mark in Texas, my essay quotes testimony by Mr. Sledge and his attorney. Please compare your assertion against the testimony that is part of the RICO trial record. Heck yeah, oh my gosh, I would love to see the plea deal debate go on and on. It's been a good time. And what are you guys thinking? Oh, we're trolling about trolling? I don't know. Okay. This is the Georgia Supreme Court. This is the Supreme Court of Georgia, you guys. Wonderful, wonderful argument. And like, just trying to imagine a response, I tried to stop and pause where I could guess one thing that they were going to say and bring up that I think won't really land. But Rice Street says, send the trolls my way, mod. Oh, man. But just super awesome. Super, super awesome. And then I will clip this out. I know we've covered 3 things on this stream. I will clip this reading out in case anyone tuned in later. Of course, people that aren't here right now that didn't know this came out. Super, super awesome. This is docketed. Well, and they still have to be granted the right to be heard when there is an amicus filing. But at least there's an argument date set for October 22nd. So of course on that day we'll see, you know, Ashley Merchant's helping to represent Steele. So is his wife Colette and Alex Souser. I believe who else we have? We have Lindsay Barron and then Leanne Webster. So I imagine, I don't know who we'll see actually there arguing, but I imagine it would probably be one of these 3. We've already seen oral arguments from Ashley Merchant and Alex Souser in the Fulton County Superior Court, the day that he was held in contempt. So I imagine one of these 2 will probably be making the arguments. It'd be so cool to see Colette make the arguments. C is for Colette. And if the amicus can make an argument, there was already one filing one brief back in August with, and I had it wrong. I didn't realize Palmer was on the first one, but Amanda Palmer was part of the first. So was Donald Samuel and Edward Tolley. And then today we have these 4. So maybe 2 of these, a party from each, will also be making arguments on October 22nd. We will absolutely tune in. I would imagine on this day, you guys, if YSL Trial is in session, I would do a late stream to catch up on YSL and prioritize this. This is going to be so interesting to watch. So interesting to watch. So, but that's what I've got. I'll paste the document again. And I also want to post the Nick Starro trial stream, because we're going to be doing that in a few hours. Oh, and he's live, so I can spill him into, we'll do that. We can redirect over to Nick. This is Nick's channel link. But I can also, let me set up a redirect link. That way when we close this out, and this is the point of the stream, you guys. Where are you going to hang out? Shout somebody out? What do you feel like watching more of? Although I do hope one of the things you do at 6 p.m. Eastern today is tune into Nick Starro's Friday YSL panel stream. I'll get this redirect set up. I had a great time reading that brief. I loved it. I loved it. I loved it. Loved it. I'm so glad you guys were here for it. Redirect. mean, come on. Give me a redirect, Nick Starro. There we go. So this will spill in. There we go. No jury today because it seems like there might be an illness. Someone might be sick, one of the jurors. It didn't seem like it was that extreme that they guaranteed that the jury wouldn't be here today. They had to figure out late if the jury would be back. So hopefully it's a minor issue. Maybe just, you're contagious. You don't want to be sitting in the jury pool. Give everyone the day off. And then recess. The court recessed because no one was prepared to argue any evidentiary issues. So Mark Harris, new amicus brief in Steele versus State of Georgia. So the contempt hearing. So we just rewatched that. Before that, we looked at the Georgia Senate hearing where Fani Willis didn't show up, and saw a lot of arguments about what legislative powers are currently over subpoenas to the executive branch. And then we watched, was that an hour and 15 minutes or so of court before they recessed today? I think that's really the summation of this stream. So we're going to set up the redirect. We'll be going over to Nick Starro. You guys feel free to shout out anywhere else worth watching. And again, big shout out to... Oh yeah, so that was while we were figuring stuff out. I have been planning to do a DK Walter Murphy rewatch. That might be something we do this weekend, or if there's another court day that's closed off. I've been doing rewind, so if you guys see me schedule something called a rewind, it's probably a look back at something that's either happened pre-trial or earlier in these 129 days of trial so far. But I do think DK Walter Murphy will be the next one. So that will be that. And in case the redirect doesn't work, this is Nick's current live stream. But again, if you just want to make sure you're able to catch the Friday panel stream, hit the subscribe button. And with that, we're going to end it with something some of you guys may be familiar with, but I think it's very appropriate considering we just went through this appeal brief. So, without further ado, you guys have a great Friday. Maybe see you later. Take care.
A as in Alicia, and B, Your Honor, as in Barry. C as in Colette.
G as in Goldfetter, K as in kittens, M as in magic, P as in perfect, C as in Colette, U as in unbelievable, V as in victory, W as in wonderful.
O for objection, S for sustain, E for buffering, E for peptopane. S for sly, my friend, and you, as in what you mean. I as in I don't recall, M as in may I sleep. All the ABCs of steel makes me feel so real. Yeah, they keep on spinning round, never gonna let me down. G for gavel slams down T, T for tell them anything, R for rights we stand, I for infinity. Life's a courtroom dance, keep your stances strong. With ABCs of steel, you can never go wrong. Oh, the ABCs of steel makes me feel so real. Yeah, they keep on spinning round, never gonna let me down. Oh, the ABCs of steel makes me feel so real. Yeah, they keep on spinning round, never gonna let me down. Oh, the ABCs of steel